What's going on, everybody? I don't know if you heard the news, but Simon Ateba has appealed the lower court's decision. I wanted to read his original complaint and that lower court's decision. I don't think we've seen a lot of documents in the appeal yet, but let's prepare for that and jump right into it. We're going to have our nifty little text aloud reader.
Plaintiff's verified complaint. Plaintiff Simon, complaining against the above-named defendants. Collectively,
Do all the heavy
White House
lifting.
or defendants, alleges as follows. Introduction 1. A free and robust press is vital to a healthy democracy. The framers understood this to be an unassailable truth, enshrining protection of the free press in the First Amendment as an essential check on government power. This constitutional safeguard is at its zenith when the government itself is the subject of scrutiny. 2. The press does not just include a small class of elite journalists, credentialed by one another. The First Amendment's guarantees protect the public's right to engage in constitutionally protected press activity. Indeed, the inclusion of the words "the press" in the First Amendment does not confer upon journalists a title of nobility. 1-3. Mr. Ateba is the White House correspondent for Today News Africa, a daily online news publication primarily covering American politics and relations between the United States and African countries. Just like other White House correspondents, Mr. Ateba regularly interacts with, and requests information from, the White House press office for his coverage. But in the 5 years since joining the White House press corps, Mr. Ateba has been treated with contempt by the current press secretary, Karine Jean-Pierre, and her staff, receiving only a handful of responses to questions and almost no opportunity to meaningfully communicate with the White House. 4. Given his publication's focus on U.S.-African relations, Mr. Ateba's questions often relate to issues other White House correspondents do not cover. The White House's refusal to communicate with Mr. Ateba significantly undermines his ability to properly inform his readers. Mr. Ateba covers topics affecting millions of people around the world, and many of his colleagues have little interest in asking the questions to which Mr. Ateba wants answers. 5. After months of not receiving answers to his inquiries from the White House press office, Mr. Ateba chose to utilize the only option available to him, speaking up during press briefings. On several occasions since December 2021.
How's it going, chat? If you're just joining us, I did want to see if Mr. Ateba's name would articulate a little better if I spelt it out phonetically. It doesn't really make a difference, but when you hear Mr., it's referring to Mr. Ateba. So if you see right here, phonetically, that's the only thing I really changed in the document besides taking out page numbers and other things like the court case number. It's at the header in each page, which really kills the flow. So let's continue where we were.
2021, Mr. Ateba asserted himself in the briefing room, speaking over other reporters and the White House press secretary in an attempt to make one Honorable David B. Santel, freedom of the press, a liberty for all or a privilege for a few. Cato Institute, September 17, 2013. His concerns known. 6. While Mr. Ateba has garnered national attention for his approach, he simply wants to do his job. To do this, he must be treated like any other correspondent, which includes having access to the White House and an open dialogue with the White House press office. 7. But the White House has made clear it does not intend to treat Mr. Ateba like his colleagues. Quite this opposite. The White House press office recently revised its credentialing criteria for media hard pass this past May in a brazen attempt to exclude Mr. Ateba from the White House briefing room. As of August 1, 2023, over 440 previously credentialed White House reporters no longer have hard pass access to the White House media facilities under the new requirements. 2. While other reporters were affected by the revisions, excluding Mr. Ateba was the primary objective because the White House no longer wanted to deal with him or his questions. 38. Targeted changes to hard pass credentialing qualifications
going
to exclude
over,
specific journalists is troubling by
Mr.
itself,
Ateba's
but the new credentialing
complaint
criteria the White House adopted also
and
raised grave
the
First Amendment
court's
concerns for
response
reporters
to
generally.
that.
As a prerequisite to obtaining a 2 Gabriel
He's
case, more than
he's a
440 reporters
reporter
lose press passes
from
after White
Africa,
House changed
but he's one of the better
Fox News,
reporters in the
August
pool.
4,
He actually
2023,
asks real questions.
www.foxnews.com web link. 3. Stephen Nelson, White House unveils new press badge restrictions, rules for access. The New York Post, May 5, 2023, NewPost.com web link. The move is widely believed to be spurred by interest in stripping African journalist Simon Ateba of his access to the briefing room after a series of disruptions. Though people involved in discussions said that White House staff had talked about making changes even before it became a minor celebrity. Justin Bragg-Ona White House wants new rules to shut down briefing room chaos. Daily Beast, March 27, 2023, www.dailybeast.com web link. Paul Farhi, new White House rules. Reporters can be kicked out if not professional. Washington Post, May 9, 2023, www.washingtonpost.com web link. Brianna Lyman, exclusive, WHCA advises Biden admin on new rules governing press passes. Daily Caller, May 11, 2023, dailycaller.com web link. White House hard pass. The applicant must, among other things, first have press credentials from the Supreme Court or one of the 4 congressional press galleries. For Mr. Ateba, like many journalists, this is no easy task, and it further bears no logical relation to covering the White House, a different branch of government. 9. Obtaining credentials from the Supreme Court is generally effectively impossible for any White House-focused journalist, because the court only gives out a limited number of passes, and only to reporters who cover the court full-time. 10. The congressional press galleries are only slightly better. Executive committees self-selected by the journalists who make up the Congressional Press Corps govern each of the 4 press galleries. And these executive committees only issue press credentials to journalists they themselves deem to be of repute. As a result, the entrenched, mainstream media have the power to pick and choose which reporters may access Congress and the White House. These decisions are subject to the final approval of the Speaker of the House and the Senate Committee on Rules and Administration. But in practice, whatever the correspondence committees say, goes. 11. Mr. Ateba applied for credentials to the Congressional Daily Press Gallery on June 5, 2023, and has yet to receive any word on the progress of his application. 12. Defendant's modification of the White House hard pass criteria means Mr. Ateba is no longer able to set foot on the White House grounds without going through the daily process of receiving short-term approval. For a journalist seeking regular access to the White House briefing room, this cumbersome process is untenable long-term. 13. Moreover, the process adopted by the White House, i.e., delegating access to the White House hard pass to the other branches of government, is an unconstitutional attempt to arbitrarily restrict who qualifies as the press. Established media outlets control the Congressional Correspondence Committees, which only provide press credentials to reporters who meet the vague standard of being a reputable journalist. Congress gave the committees unbridled discretion to pick and choose which journalists can exercise their constitutional rights at the Capitol. The White House has incorporated this delegation into its own credentialing process.
We're checking
and with
out
it,
the
same constitutional
case
infirmities.
Mr. Ateba
14.
has against
Defendants
Karine
do not like Mr.
Jean-Pierre.
Ateba's behavior or his questions during press briefings. But instead of enforcing a decorum requirement equally across all White House correspondents, defendants simply redefined who is allowed in the door in the first place. And they did so to specifically exclude Mr. 15. Defendants' intentional discrimination against Mr. Ateba and the conditions the White House has placed on obtaining a hard pass violate the First Amendment. Mr. Ateba brings this action to vindicate his constitutional rights, the same rights shared by all other members of a free press. Jurisdiction and venue 16. This action arises under the First Amendment to the United States Constitution, the Declaratory Judgment Act, 28 U.S.C. Sections 2201 and 2202, and the Administrative Procedure Act, 5 U.S.C. Sections 701, et sec. This court has subject matter jurisdiction over this action pursuant to 28 U.S.C. Sections 1331 and 1361. 17. Venue is proper in this district pursuant to 28 U.S.C. Section 1391b, 2, and e1. A substantial part of the events giving rise to this claim occurred in this district, and defendants are officers of the United States sued in their official capacities. Parties 18. Mr. Ateba is the White House correspondent for Today News Africa, TNA, an online publication that focuses on relations between the United States and African nations. Mr. Ateba has been a journalist for over 15 years and has regularly covered politics and public affairs in both Africa and in the United States. Mr. Ateba has been the White House correspondent for TNA since 2018. He has held a White House hard pass since February 2021. 19. Defendant Karine Jean-Pierre is press secretary to the President of the United States. As press secretary, Ms. Jean-Pierre is in charge of the White House Press Office, the organization responsible for credentialing reporters for the White House press facilities. She is sued in her official capacity. 20. The United States Secret Service is a federal law enforcement agency that administers and oversees
Let me know in the
security of the
chat
White House.
if it was
The
as
Secret
bad
Service
with the
performs background
last
checks on those
girl,
seeking a White House
lady.
hard pass
I
and is
can't
the agency
remember her name.
ultimately
She's the
responsible for issuing
redhead.
the hard pass.
She was
21.
really hard to
Chief
listen
Director
to.
of the United States Secret Service.
I don't
She is
know
sued
if
in her
she was
official
just
capacity.
as
Statement of facts. The White House Press Room, 22.
hard on
The
Simon
James J.
not
Brady Press
calling
Briefing
on
Room is
him.
perhaps the most important forum for news media to interact with the President of the United States and his staff. Nearly every major media outlet in the country, and many others around the world, has a designated correspondent station
She
at
has
the White
a
House to report
full-on
on the daily
propaganda
activities of the
show
President and his
now.
administration.
I don't know.
The White House Press Corps,
I don't
however,
watch it. I
also
don't know
includes
who she
reporters
is.
from
I
smaller
forget her
outlets,
name.
ranging from startups to regional
How
publications.
quickly
In the briefing room,
we forget.
correspondents from the New York Times, Washington Post, CNN, and ABC News sit shoulder to shoulder with correspondents from publications with a mere fraction of the viewership and subscriber base of the larger outlets. 23. For all journalists, the White House briefing room serves as an essential access point for those seeking to cover the President of the United States. 24. But it is not a place for the faint of heart. Reporters must fend for themselves.
Is
in
it
order to do their
random
job,
that
which is to obtain
he's?
information
You mean
for their
random
viewers,
by?
viewers,
Is it
and
random
listeners.
that they're not
25.
calling on
The
him?
unpredictable
Because
and
if
volatile
they're
atmosphere
he's
of press
asking
briefings
tough
leads to
questions they
tense
don't want to
exchanges.
answer.
And,
And the
of course,
reason we're
raised
covering
voices.
this today is
Yet the briefing
because
room has
just
historically operated
yesterday, or
under a
maybe
more than informal
the day
understanding that all
before,
correspondents must
Mr.
act professionally.
Ateba
And while
filed
some
an appeal.
administrations have adopted more formal expressions of their decorum expectations, they largely
Let me know
insist
what
on
kind of
and
random.
only. Despite the many instances where journalists fail to adhere to these expectations, formal punishment for decorum violations is exceedingly rare. 26. Journalists seeking access to the White House press facilities and briefing room must have the proper credentials. The White House issues short-term passes for 1 day up to 6 months. These passes require the individual to submit to heightened Secret Service scrutiny each time they come to the White House. 27. Some journalists can obtain a hard pass, a special form of press credentials that allows unlimited access to the White House press facilities. As the White House Correspondents Association previously advised, a hard pass is critical for anyone who reports regularly on the White House. It is no exaggeration to say that, without the access that a hard pass grants, a White House correspondent cannot effectively perform his or her duties, which include providing the public with on-the-spot news coverage of unforeseen and unscheduled events, along with cataloging the daily activities of the head of the executive branch. 428. The White House has had no shortage of controversy surrounding revocation of for a brief of amicus curiae. The White House Correspondents Association in support of appellee seeking affirmance. Karine v. Trump. Case number 19 to 5255. D.C. January 13, 2020. Citation omitted. Press credentials. The Washington Post has had press credentials revoked from its journalists on numerous occasions after provoking the ire of various presidents and their staff over scandals, including Watergate and the Pentagon Papers. 5 Arbitrary enforcement of the White House press credentialing regime has even resulted in litigation. 629. Strained relations between the White House and the press corps persisted during the Trump administration. High-profile examples include the Trump White House revoking the press credentials of CNN White House correspondent Jim Acosta and Playboy correspondent Brian Karem. 30. The 2018 Acosta incident followed months of tense exchanges during press briefings between the CNN correspondent and the White House press staff. Mr. Acosta regularly spoke over the press secretary during exchanges. Other White House correspondents expressed dismay at Mr. Acosta's behavior. During one particularly heated exchange, Mr. Acosta refused to give up the microphone during a briefing, prompting the White House to revoke his hard pass. 31. The White House Correspondents Association strongly objected to the Trump administration's decision to use U.S. Secret Service security credentials as a tool to punish a reporter with whom it has a difficult relationship. 732. The Trump White House also revoked the hard pass of Playboy correspondent Brian Karem in 2019 following an incident at a social media summit in the Rose Garden between Karem and a Trump administration advisor. This prompted the White House to revoke his 5 Jason Daly, The Complicated History Between the Press and the Presidency. Smithsonian Magazine, June 14, 2016, www.smithsonianmag.com web link. 6 Cheryl v. Knight, 569 F.2D 124, D.C. 1977, 4 KV. Knight, 416 F. Sup. 1025, DDC. 1976. 7. Richard Gonzalez, White House revokes press pass of CNN's Jim Acosta, NPR, November 7, 2018, www.npr.org web link. Credentials for unprofessional conduct. 33. Both reporters went to court over the revocation of their hard passes. 8. The district court found Acosta was likely to succeed on the merits of his claim and issued a preliminary injunction requiring the White House to reinstate Acosta's credentials. The White House did not appeal the district court's injunction. 934. Karam's case went to the D.C. Circuit, which held revocation of his press pass by the White House violated his due process rights. The court concluded that Karam had a liberty interest in his press pass and that he was not on notice that his conduct that arose could lead to the revocation. This failure to provide notice was a deprivation of procedural due process. 35. Following the lawsuit filed by Acosta, the Trump administration revised the press credentialing requirements to obtain a hard pass. 10. The revisions included the onerous requirement that journalists appear on the White House grounds for 90 of the previous 180 days to qualify for a hard pass. The practical impact of this new requirement was that many longtime White House reporters lost their credentials. 36. Though the Trump White House argued the new credentialing requirements were necessary due to security concerns, many journalists speculated that the changes were intended. 8. Karam v. Trump, 960 F.3D 656, D.C. 2020, Cable News Network Incorporated v. Trump, number 18 2610, DDC November 16, 2018. 9. Cable News Network Incorporated v. Trump, number 18 to 2610, DDC November 16, 2018. See also Ed Pilkington, CNN sues White House and demands return of Jim Acosta's press credentials. The Guardian, November 13, 2018, www.theguardian.com web link. A journalist may not be stripped of access because of distaste for his questions, a desire to retaliate against him for prior coverage, or frustration at what the president may view as a hostile attitude. 10. Matthew Ingram, White House revokes press passes for dozens of journalists. Columbia Journalism Review, May 19, 2019, www.cjr.org web link. To prevent specific journalists from obtaining a hard pass. 11. Indeed, the Trump White House provided exemptions to certain journalists that it deemed worthy of keeping the hard pass. 1237. The media's most powerful institutions and civil liberties advocates alike uniformly denounced the new credentialing requirements and practice of handing out exemptions. The ACLU blasted the move as un-American. 13. The collective response from free press advocates was that the White House's new credentialing requirements were a direct assault on the First Amendment. Mr. Atba's coverage of the White House. 38. Mr. Ateba is the White House correspondent for the daily online publication Today News Africa. 14. Mr. Ateba has been a journalist for the past 15 years, covering politics and current affairs in both Africa and in the United States during most of that time. This includes covering both the United States State Department and the White House for the past 5 years. 39. Mr. Ateba became a White House correspondent in 2018. For his first 3 years covering the White House, Mr. Ateba obtained a temporary daily press pass, which required him to go through additional Secret Service security prior to entering the grounds. 40. Mr. Ateba applied for, and received, a White House hard pass in February 2021. 41. Since then, Mr. Ateba has covered the White House on a daily basis. He writes 11. Chris Ryda, Trump administration commits mass purge of journalists allowed to enter White House. Independent, May 10, 2019, www.independent.co.uk web link. 12. Paul Farhi, White House imposes new rules on reporters' credentials, raising concerns about access. Washington Post, May 8, 2019, www.washingtonpost.com web link. 13. Pilkington, Supra. 14. PodanesAfrica.com. Regular stories for TNA, which requires regular communication with the White House press office. Thus, Mr. Ateba frequently sends questions to the White House press office and attend the White House press briefings. 42. Over his 5 years as a White House correspondent, Mr. Ateba has rarely received any response, or even acknowledgement, of his questions from the White House. Regardless of what the questions are, the White House generally ignores them. This refusal to provide information to Mr. Ateba makes it increasingly difficult for Mr. Ateba to obtain the necessary information needed for the quality of coverage he seeks to provide his readers. 43. Mr. Ateba has been allowed to attend President Biden's press conferences just once in nearly 3 years. When he attempts to attend, he is denied access. For the press conferences he was allowed to attend, he was not allowed to ask a question. 44.
It's
Mr.
kind of
requested an
crazy when
opportunity
you
to
think
interview
about
President
it.
Biden in the lead up to an African Leaders Summit at the White House in December 2022. These requests were completely ignored. 45. After months of not receiving responses to written questions from the White House and not receiving an opportunity to ask questions in the briefing room, Mr. Ateba resorted to one of the only options available to him, speaking up during press briefings. 46. It is common for White House correspondents to raise their voices and even shout over each other during press
Revisit
briefings.
the Ted Lasso of it all
the DC Circuit
soon.
has acknowledged that, in the context of a White House press corps described as an unruly mob, behavior such as a journalist shouting questions and engaging in a sarcastic, irreverent, caustic back and forth with White House staff was not so outrageous as to bring into fair contemplation a suspension of a reporter's hard pass. 1547. Just like his colleagues, Mr. Ateba would engage in the scrum, shouting his questions to the White House press secretary questions during briefings. And on a few occasions, when the press secretary would not acknowledge him, Mr. Ateba would speak over his fellow journalists. 48. The White House did not appreciate this breach of decorum. 49. One notable incident took place on March 20, 2023. The press secretary began the daily briefing by introducing the cast of the hit Apple TV show Ted Lasso. The White House invited the group to the briefing to discuss the president's mental health initiatives. Before the press secretary could finish the introduction, Mr. Ateba began speaking, questioning why he has not received any responses to his written inquiries or been given the opportunity to ask a question during the press briefing. A tense exchange between Mr. Ateba and the press secretary followed, which included shouts from other correspondents for decorum. 50. The March 20th incident received national media attention. 1651. Another notable incident took place on June 26, 2023. In another attempt to receive answers from the White House regarding its refusal to respond to his questions, Mr. Ateba interrupted a fellow correspondent during a daily press briefing. Mr. Ateba pressed forward with his questioning, despite his fellow correspondents asking him to stop. The White House went as far as to scroll video footage of this incident in which the press secretary told Mr. Ateba that he 15 Karam, 960 F.3D at 665. 16. Jamie Burton, Ted Lasso's visit to the White House descends into chaos. Newsweek, March 21, 2023, www.newsweek.com web link. was being incredibly rude from its YouTube live stream.
Descends into
52.
chaos.
Since December 2021,
A
Mr.
man
Ateba has
asked
asserted
the
himself during press
question.
briefings on a
Imagine
number of
that.
occasions. The mainstream media coverage of these incidents has largely painted Mr. Ateba as disruptive, disrespectful,
Chaos.
and even seeking attention for himself. But Mr. Ateba is simply seeking answers to his questions, which the White House refuses to give. 1753. The White House did not like these exchanges and wanted them to end. 18. The White House targets Mr. Ateba. 54. On information and belief, the significant media coverage focusing on Mr. Ateba's conduct in the briefing room prompted the Biden White House to act. On May 5, 2023, the White House notified all existing hard pass holders that it was restricting who could qualify for a hard pass. See Exhibit A, email announcing the new White House Press Office policy. The White House Press Office issued a new list of stated criteria for obtaining a hard pass, and required that all existing hard passes terminate on July 31, 2023, and that journalists would have to apply for a new pass under the updated criteria. 55. The new criteria include full-time employment with an organization whose principal business is news dissemination. If you are freelance, we will need letters from 2 news organizations describing your affiliation. Or, if you freelance primarily for one organization, a letter from that organization describing the extent and duration of your relationship with the organization. 17. For example, Joseph Bernstein, why won't Simon stop shouting? July 27, 2023, New York Times, www.newyorktimes.com web link. Paul
Because
Farhi,
no one
White
will
House warns
answer
reporter
him.
Simon about his press room outbursts. The Washington Post, July 12, 2023,
Spineless reporters.
www.washingtonpost.com
Are there any
web
real
link.
journalists
18
left?
News
Chat,
Press,
let me
White
know.
House scrubs video of reporter Simon confronting Karine Jean-Pierre. Real Clear Politics, June 26,
Simon might be the
2023,
last one.
www.rattleclearpolitics.com web link on _the_confronting_Karina_Jean-Pierre.html. Physical address, either residential or professional, in the greater Washington, D.C. area, have access to White House campus at least once during the prior 6 months for work, or have proof of employment within the last 3 months to cover the White House, assignment to cover, or provide technical support and covering the White House on a regular basis, accreditation by a press gallery in either the Supreme Court, U.S. Senate or U.S. House of Representatives, and willingness to submit to any necessary investigation by the U.S. Secret Service to determine eligibility for access to the White House complex, where Secret Service will determine eligibility based on whether the applicant presents a potential risk to the safety or security of the President, the Vice President, or the White House complex. 56. Mr. Ateba objected to the new hard pass requirements and requested the White House delay implementation for 1 year to allow him time to obtain press credentials from a congressional press gallery. The White House never responded to his request. 57. Media outlets widely reported that the new hard pass requirements were targeted directly at Mr. Ateba. 19. His high-profile exchanges with the White House press secretary during briefings had garnered both international media attention and provoked the anger of the Biden administration. 58. Additional actions taken by the White House confirmed that the new hard pass criteria targeted Mr. Ateba. On July 27, 2023, the White House took the rare step of issuing a written warning to Mr. Ateba regarding this conduct during daily press briefings. See Exhibit B, Letter of 19 Stephen Nelson, White House unveils new press badge restrictions, rules for access. The New York Post, May 5, 2023, NetPost.com web link. Justin Dragona White House wants new rules to shut down briefing room chaos. Daily Beast, March 27, 2023, www.dailybeast.com web link. Reprimand to Mr. Ateba. The letter described 4 specific instances in which Mr. Ateba allegedly disrupted the daily press briefings. If Mr. Ateba continued this conduct, the letter warned, his hard pass may be suspended or revoked, following notice and an opportunity to respond. 2059. In the letter, the White House also pointed to the new decorum criteria it announced in May and advised Mr. Ateba that he must adhere to these expected standards or risk revocation of his press credentials. The press credential gatekeepers. 60. The threat of revoking Mr. Ateba's press credentials was largely meaningless because the White House knew he would not qualify for a hard pass under the new criteria. Indeed, excluding Mr. Ateba was the goal of the specific revisions. 61. The White House Press Office's new criteria for a hard pass includes requirement that an applicant must first be credentialed by the Press Gallery of the United States Supreme Court, or one of the press galleries in either chamber of Congress. 62. Consistent with the White House Press Office's warning, the U.S. Secret Service terminated Mr. Ateba's hard pass on July 31, 2023. 63. Mr. Ateba's hard pass was not scheduled to expire, and would automatically renew so long as he continued covering the White House. 64. On August 4, 2023, Mr. Ateba requested the White House press delay termination of his hard pass until his application to the Daily Congressional Press Gallery or Supreme Court was approved or denied. The White House refused this request. 65. The termination of plaintiff's hard
Why
pass
did they
represents the culmination of
treat him
agency
that
action,
way?
and thus, is a final agency action. See 7 U.S.C. Section 704. While plaintiff can, and did, apply for new 20 id. Hard pass. This is a new agency action, not a reinstatement of plaintiff's prior pass. 66. The Secret Service's termination of Mr. Ateba's hard pass is arbitrary and capricious. When agencies change a policy, they are required to provide reasoned explanation for its action, including showing that there are good reasons for the new policy. The Secret Service has failed to do so, relying instead on the White House Press Office policy, which itself was issued without any explanation, let alone reasoned explanation. 67. The Supreme Court Public Information Office is responsible for issuing press credentials to journalists seeking to cover the court. 21. The press gallery at the Supreme Court is notoriously small with only 18 seats for journalists in the argument room. As a result, the Supreme Court only issues press credentials to journalists whose full-time beat involves coverage of the Supreme Court. 22. Reporters who primarily cover the White House cannot qualify for a Supreme Court pass. 68. Obtaining credentials from one of the congressional press galleries is Mr. Ateba's only option for obtaining a White House hard pass. This is not a viable option, either. 69. The media has been covering Congress since its earliest sessions.
We're
23. The press
almost
have
done
designated
here on
galleries in both
Simon
chambers of Congress.
Ateba's complaint
These galleries
against
include office
Karine
space and work. 21. Supreme Court
Jean-Pierre
Public
et
Information
al.
Office. www.supremecourt.gov.
And then we're going to go on to the
711023.pdf.
lower
Press
court's
credential
decision.
requirements. 22. id. The PO has traditionally reserved hard passes for full-time
He
professional
just
journalists
filed his
employed by media
appeal
organizations
on
that
the
have records of
11th.
substantial and original news coverage of the court and a demonstrated need for regular access to the court's press facilities. 23. Sarah J. Ekman, Congressional News Media and the House and Senate Press Galleries, Congressional Research Service, April 17, 2023. Resources for credentialed journalists covering Congress. 70. Ever since the late 19th century, Congress delegated regulation of access to the congressional press galleries to the Correspondence Committees, a group of journalists elected to oversee credentialing and other administrative aspects of the congressional press galleries. Today, there are 4 Correspondence Committees: the daily press galleries, for daily news publications; the periodical press galleries, for weekly, monthly, and quarterly publications; the radio and television galleries; and the press photographers gallery. Each chamber of Congress has provided professional staff for each respective press gallery. 71. The Correspondence Committee for each gallery is made up of 5 or 6 members, all journalists who already have press credentials. The Executive Committee of the Daily Press Gallery, for example, is made up of journalists from the Detroit News, CQ Roll Call, the Associated Press, the Pittsburgh Post-Gazette, and States Newsroom. 24 These standing committees process applications based on the respective credentialing criteria adopted by each gallery. They are the gatekeepers to the press credentials. 72. To qualify for press credentials for the Daily Press Gallery, a journalist must be a bona fide correspondent of repute in their profession, a full-time, paid correspondent who requires on-site access to congressional members and staff, employed by a news organization, with general publication periodicals mailing privileges under U.S. Postal Service rules, and which publishes daily, or whose principal business is the daily dissemination of original news and opinion of interest to a broad segment of the public, and which has published 24 Standing Committee of Correspondence, U.S. Senate Press Gallery, www.dailypress.senate.gov web link, last visited August 8, 2023 at 11 p.m. Continuously for 18 months, reside in the Washington, D.C. area, not be engaged in any lobbying or paid advocacy, advertising, publicity or promotion work for any individual, political party, corporation, organization, or agency of the U.S. government, or in prosecuting any claim before Congress or any federal government department, and will not do so while a member of the Daily Press Galleries, and they must be editorially independent of any institution, foundation or interest group that lobbies the federal government, or that is not principally a general news organization. 2573. The other press galleries have similar requirements. 2674. This gatekeeping function has had a dramatic effect on outlet diversity in Congress over the past decade. In 2017, the Congressional Research Services found that the number of credentialed correspondents in Congress increased from around 2,500 in 1976 to 6,000 in 2016. But during that same period, the number of credentialed media outlets dropped from over 1,200 to fewer than 600. This drop in the number of media outlets covering Congress supports the notion that the correspondence committees responsible for credentialing have become increasingly insular and hostile to outsiders. Mr. Ateba persists. 75. In response to the new restrictions the White House adopted for hard passes in May 2023, Mr. Ateba applied for press credentials with the Standing Committee of Correspondence for 25. See www.dailypress.senate.gov web link. Criteria for press credentials. 26. See periodical.house.gov web link. Criteria for press credentials. www.radiative.senate.gov web link. Same. www.pressphotographers.senate.gov web link. Same. The Daily Press Gallery. 76. Mr. Ateba submitted his application on June 5, 2023. See Exhibit C, letter from to Senate Daily Press Gallery. He has yet to receive a response. 77. Mr. Ateba applied for press credentials from the Supreme Court Press Office on August 3, 2023. See Exhibit D, letter to the Supreme Court Public Information Office. The Supreme Court Press Office informed Mr. Ateba that he was not eligible for court press credentials because he does not cover the Supreme Court full-time for his publication. 78. On information and belief, the Supreme Court Public Information Office has informed the White House that it will not issue hard passes for any White House journalists due to space constraints at the court. The Supreme Court's Public Information Office indicated as much to Mr. Ateba. Mr. Ateba intends to prove this through discovery. 79. Knowing he would be denied for not having the requisite credentials from a congressional press gallery or the Supreme Court, Mr. Ateba initially did not apply for a White House hard pass renewal by the July 31st deadline. 80. Out of an abundance of caution, Mr. Ateba reapplied for a White House hard pass on August 4, 2023. 81. Despite being specifically targeted by the White House for exclusion, and despite being subject to the unbridled discretion of the Standing Committee for the Congressional Press Gallery, Mr. Ateba will continue to cover the White House for TNA. Though this job has become exceedingly more difficult without a hard pass, Mr. Ateba is determined to continue providing quality coverage for his readers. 82. But without a hard pass, Mr. Ateba is, and will continue to be, irreparably harmed. Defendants have infringed on his constitutional rights, and this infringement will persist absent intervention by this court. First claim for relief: violation of the First and Fifth Amendments, delegation of unbridled discretion. 83. Mr. Ateba hereby incorporates by reference all other paragraphs of this verified complaint as though fully set forth herein. 84. The hard pass criteria adopted by the White House Press Office in May 2023 violate the First Amendment. By requiring that all applicants obtain press credentials from the Supreme Court or one of the congressional press galleries, defendants have adopted a regime that gives the government unbridled discretion to permit the exercise of First Amendment rights. 85. The 4 congressional press gallery standing committees wield this unbridled discretion, only approving credentials for journalists they deem are reputable. The failure to adopt and apply purely objective standards for congressional press credentials renders the credentialing process unconstitutional. The White House has incorporated this credentialing process into its own hard pass criteria, rendering the White House process constitutionally impermissible as well. 86. Defendants have no compelling reason to justify this impermissible credentialing process, nor is this process narrowly tailored. 87. Mr. Ateba has no adequate remedy at law, has suffered, and will suffer serious and irreparable harm to his constitutional rights unless the White House is enjoined.
We're almost done with this
Mr. Ateba
complaint.
is entitled to declaratory relief and temporary, preliminary, and permanent injunctive relief invalidating and restraining the White House from violating his constitutional rights. 89. Mr. Ateba found it necessary to engage the services of private counsel to vindicate his rights under the law. Mr. Ateba is therefore entitled to an award of attorney's fees and costs pursuant to 28 U.S.C. Section 2412. Second claim for relief: violation of the First Amendment, viewpoint discrimination. 90. Mr. Ateba hereby incorporates by reference all other paragraphs of this verified complaint as though fully set forth herein. 91. Defendants violated Mr. Ateba's First Amendment rights by changing the criteria for hard pass credentials to intentionally prevent Mr. Ateba from obtaining hard pass access. Defendants did so by adopting credentialing criteria specifically designed to exclude Mr. Ateba from eligibility. Such discrimination amounts to a content-based regulation and viewpoint discrimination against Mr. Ateba in violation of the First Amendment. 92. Defendants have no compelling reason to exclude Mr. Ateba from obtaining a White House hard pass. Even if they did, this exclusion is not narrowly tailored to achieve this interest. 93. Mr. Ateba has no adequate remedy at law, has suffered, and will suffer serious and irreparable harm to his constitutional rights unless the White House is enjoined.
Hey, Josh.
94.
There's like
Mr.
2
Ateba is
good
entitled to
reporters
declaratory
in the
relief
White
and
House
temporary,
press
preliminary,
pool, and one of
permanent
them has
injunctive
just
relief
been
invalidating and
denied
restraining the White House from
credentials.
violating his constitutional rights. 95. Mr. Ateba found it necessary to engage the services of private counsel
He's
to vindicate his
appealing the
rights under the law.
decision.
Mr.
We're
Ateba is
gonna
therefore entitled to an award of attorney's fees and costs pursuant to 28
read that
U.S.C.
next.
Section
We're almost done here with his
2412.
complaint.
Third claim for relief violation of the Administrative Procedure Act. 5 U.S.C. Section 702, 96. Mr. Ateba hereby incorporates by reference all other paragraphs of this verified complaint as though fully set forth herein. 97. The Secret Service is an agency within the meaning of the Administrative Procedure Act. 98. On July 31, 2023, the Secret Service terminated Mr. Ateba's hard pass. 99. The termination of Mr. Ateba's hard pass is a final agency action. 100. The termination of Mr. Ateba's hard pass is also a change in agency policy or position. 101. The Secret Service has failed to provide any reason to justify terminating Mr. Ateba's hard pass, let alone a good reason or reason explanation. Instead, the Secret Service appears to be relying on a policy issued by the White House Press Office, which likewise provides no explanation for the change in policy. 102. By failing to provide a reasoned explanation for its change in policy or position, the Secret Service has acted arbitrarily and capriciously in canceling Mr. Ateba's hard pass, in violation of 5 U.S.C. Section 702. 103. By virtue of the ongoing violation of Mr. Ateba rights, Mr. Ateba is entitled to a declaration that the Secret Service's cancellation of Mr. Ateba's hard pass was arbitrary and capricious, and an injunction preventing the Secret Service from canceling Mr. Ateba's previously issued hard pass. Prayer for relief. Wherefore, plaintiff Simon prays this honorable court grant the following relief in his favor. 1. Declaratory relief in the form of an order and declaratory judgment holding and declaring that the White House Press Office's revised credentialing requirements are unconstitutional on their face and as applied under the First Amendment to the United States Constitution for the reasons set forth above. 2. Injunctive relief in the form of a temporary, preliminary, and permanent injunction requiring the government, its agents, employees, and all persons acting in concert with them to not enforce the revised White House credentialing requirements. 3. Declaratory relief in the form of an order and declaratory judgment holding and declaring that the U.S. Secret Service's termination of Mr. Ateba's hard pass was arbitrary and capricious, in violation of law. 4. Injunctive relief in the form of a temporary, preliminary, and permanent injunction enjoining the U.S. Secret Service from terminating Mr. Ateba's hard pass without reasoned explanation. 5. That the court issue the requested injunctive relief without a condition of bond or surety or other security being required of Mr. Ateba. 6. An award of Mr. Ateba's reasonable costs and attorney's fees pursuant to 28 U.S.C. Section 2412. 7. That the court retain jurisdiction of this matter for the purposes of enforcing the court's orders. And 8. Such other relief as the court deems necessary and proper. Dated August 10, 2023. Respectfully submitted.
So this is, in America, we don't kill the journalists who ask questions we don't want to answer, but we do not let them do their jobs. It's, I guess, a step above, a few steps above, but I'm not happy with how we do it. I'm not happy with this. So Mr. Ateba is a journalist who covers the White House, and he recently had his hard pass credentials revoked, which means he has to go through security every day, and it's not sustainable long term for him. It really is a problem because he's just one of the reporters who asks tough questions, and he's appealing this. He just announced on the 11th he's appealing the decision, the lower court's decision. And so that's why we're doing this today. I mean, 2 days ago, he tweeted out that he's appealing the lower court's decision. So I wanted to read the lower court's decision, and let's get that going. So, onward.
Simon Ateba, plaintiff, v. Civil Action Number 23 to 2321, JDB, Karine Jean-Pierre, in her official capacity as White
So
House
we're
Press
about to
Secretary,
find out
et al.
together, Matt.
Defendants. Memorandum opinion. For decades, the White House has granted special access passes, known as hard passes, to journalists tasked with reporting on the president and his administration. See generally Cheryl v. Knight, 569 F.2D 124, D.C. 1977. Hard pass holders can generally come and go from the White House as they wish, subject to a security screening at the door. On May 5, 2023, the White House announced changes to the criteria for obtaining a hard pass, re-implementing a requirement that had been in place for most of the last 50 years, that the applicant hold a press credential from the Supreme Court or one of the press galleries of the United States Congress. Journalists who could not satisfy these requirements by July 31, 2023, will lose their expedited access. Simon Ateba, the White House correspondent for Today News Africa, was one of about 500 journalists whose hard passes were deactivated under this policy. Ateba, who is known for interrupting press briefings and attracting the ire of the press secretary, alleges that the new policy was designed to exclude him from the press room. In this lawsuit, he claims White House Press Secretary Karine Jean-Pierre, the White House, engaged in unconstitutional viewpoint discrimination against him by changing the criteria, and that the new hard pass policy unreasonably confers unbridled discretion on the congressional press galleries. He also claims that Director of the United States Secret Service Kimberly Cheadle and the United States Secret Service, collectively the Secret Service, acted arbitrarily and capriciously in deactivating his hard pass. Before the court are the parties' cross motions for summary judgment. Background. Factual background. Press access to the White House as the residence and offices of the President, his family, and his personal staff. Access to the White House is tightly controlled. However, the White House has voluntarily decided to establish press facilities for correspondents who need to report therefrom. Cheryl, 569 F.2D at 124. The press facilities include the James S. Brady briefing room, the press offices, the press apron, the North Grounds stand-up area, and the driveway, collectively, the press area. Leaves. Risk. To PL.S. Statement of material facts as to which there is no genuine dispute, ECF number 26-1, leaves. Risk. To PL.S. Facts, Bill Co. 1. The White House offers journalists two principal ways of accessing the press area. First, a reporter may obtain a temporary press pass, known as a day pass, which is a daily credential issued upon application to the Secret Service. PL.SRISP. TDIFS. Statement of material facts as to which there is no genuine dispute. ECF number 23-3. PL.SRISP. TDIFS. Facts. Pilcro 2-3. Second, a reporter can obtain a permanent press pass, known as a hard pass, which is a credential that allows him or her to come and go freely once the pass is issued. Id. Pilcro 2.1 day pass and hard pass holders can access the press area at the same times, from 5:30 a.m. to 10:30 p.m. Id. Pilcro 5, 3rd article. Of Nathan Fleischer, IST. To the Special Agent in Charge, Presidential Protective Division, U.S. Secret Service, ECF number 22-2, 3D Fleischer article, Pilcro 7-8. However, a 1/3 form of access, the appointment press pass, is not at issue here. PL.SRISP. TDIFS. Facts Pilcro 2. Reporter with a day pass must await an escort from the gate to the press area, which can take up to 45 minutes. Leaves. RISP. To PL.S Facts Pilcro 3-4. CED. Pilcro 4. White House disputing to the extent chaperones are available at the top of each hour.
Yeah.
Unlike a hard pass holder who can access the White House as long as his or her pass is active, a day pass
did.
user must submit a brief,
Like
online Secret Service form for each day that he or she wants to
August,
access the press area.
September to December.
PL.S RISP. TDIFS. Facts Pilcro 3. 3D Fleischer article. Pilcro 9. Journalists are directed to submit the form by 5 p.m. the night before, although the White House has also submitted evidence that passes have been granted day of, including to leaves. RISP. To PL.S Facts Pilcro 2. Because day passes are good for one day only, journalists must resubmit the form for every day they plan to access the press area. Id. Journalists seeking long-term hard passes must secure approval from the Secret Service and the White House. The Secret Service reviews whether the applicant presents a potential source of physical danger to the president and or the family of the president so serious as to justify his or her exclusion from White House press privileges. 31 CFR Section 409.1. The White House sets and enforces the remaining criteria for approval. CPL.SRISP. TDIFS. Facts Pilcro 1. These criteria are discussed at length below. B. Simon Papa is the White House correspondent for Today News Africa, a daily online news publication covering American politics and relations between the United States and African countries. Verified Compil. ECF number 1. Compil. Pilcro 3. CPL.SRISP. TDIFS. Facts Pilcro 6. He has worked as a journalist for 15 years, the last 5 as a White House correspondent. Compil. Pilcro 3. 38. For his first 3 years as a White House correspondent, he entered the White House with a day pass. From February 2021 through July 2023, he held a hard pass. PL.SRISP. TDIFS. Facts Pilcro 7. During this time, he alleges, he was ignored by the press secretary, who generally refused to take his questions or grant him interviews with the president. See Compil. Pilcro 42-45, leaves. RISP. To PL.S Facts Pilcro 9. The claims that in response to this alleged treatment, he has taken to speaking over the press secretary and other correspondents during White House briefings. Compil. Pilcro 45-53, CPL.S RISP. TDIFS. Facts Pilcro 11. In one notable incident, on March 20, 2023, he interrupted the press secretary's introduction of the cast members of the television show Ted Lasso, who were at the White House to speak about mental health. See Compil. Pilcro 49, leaves. RISP. To PL.S Facts Pilcro 10. The disturbance resulted in national news coverage. CED. Pilcro 50. His pattern of disruption has drawn rebuke from the White House press secretary and other correspondents. Id. Pilcro 48, 50, 52. Even amid the well-known rough and tumble atmosphere of the White House press area, see Karine v. Trump, 960F.3D 656, 665, DC 2020, his behavior has turned heads. See Compil. Pilcro 45-53, leaves. RISP. To PL.S Facts Pilcro 20. See changes in White House policy on May 5, 2023, the White House announced 2 new policies relating to White House access. First, the White House issued a conduct policy, setting forth expectations for behavior in the press area, and the process for revoking hard pass credentials of journalists who did not comply. Conduct policy. PL.S RISP. TDIFS. Facts Pilcro 10. See Compil. X. A. ECF number 1-1, May 5, 2023 letter, at 2. Second, the White House announced that all hard passes would expire on July 31, 2023, unless the holder met the following criteria. Hard pass policy. 1. Full-time employment with an organization whose principal business is news dissemination. If you are freelance, we will need letters from 2 news organizations describing your affiliation. Or, if you freelance primarily for one organization, a letter from that organization describing the extent and duration of your relationship with the organization. 2. Physical address, either residential or professional, in the greater Washington, D.C. area. 3. Have access to White House campus at least once during the prior 6 months for work, or have proof of employment within the last 3 months to cover the White House. 4. Assignment to cover, or provide technical support in covering, the White House on a regular basis. 5. Accreditation by a press gallery in either the Supreme Court, U.S. Senate or U.S. House of Representatives. And 6. Willingness to submit to any necessary investigation by the U.S. Secret Service to determine eligibility for access to the White House complex, where Secret Service will determine eligibility based on whether the applicant presents a potential risk to the safety or security of the President, the Vice President, or the White House complex. PL.S RISP. TDIFS. Facts Pilcro 8-9. The White House did not explain the change, except to say that it sought to be consistent with prior administrations. May 5, 2023 letter. In briefing, the White House suggested the change was made to reduce the number of passes in circulation. Mem. Of P and A. In sub. Of leaves. Mo. For some. J. ECF number 22-1, leaves. Mo. At 2. Under the now rescinded policy, hard passes were automatically renewed and there were an excessive number in circulation, including many that were no longer in active use, leading to concerns with administrability and the security risks inherent in the ballooning number of passes that grant access to the White House. Principally at issue in this case is rule number 5, the requirement that applicants hold credentials from the Supreme Court or one of the congressional press galleries. Access to the Supreme Court press gallery is determined by the Public Information Office and is limited to journalists who cover the court full-time. See Reefs.
We're not that far outside the civil rights era.
Has not secured a credential from the Supreme Court.
And
Hill Pro 14, Campbell.
it wasn't too long ago where I don't think you could find an African-American journalist in the White House press briefing room, and now, just a few years later, they're completely comfortable pretending like he's invisible.
The congressional press galleries have long provided professional credentialing to journalists. See Consumers Union of U.S. Incorporated v. Periodical Correspondence Sasson, 515F.2D 1341,
It's kind of nuts, especially because the way Biden
1975, discussing history of credential press galleries and credentialing rules. The House and Senate each host 4 galleries for different types of journalists: daily press, periodical press, radio, TV, and press photographers. CED. Committees of journalists administer the credentialing requirements for the galleries, and journalists must renew their credentials every 2 years. CDEFs. Risk. 2PL.S Fax Pilcro 15-16. The credentialing requirements for the congressional press galleries are similar to each other. The rules for the Senate Daily Press Gallery, also known as the Senate Press Gallery to which the has sought access, are, in pertinent part, 3. The Standing Committee of Correspondence shall limit membership in the press galleries to bona fide correspondents of repute in their profession, under such rules as the Standing Committee of Correspondence shall prescribe. 4. An applicant for press credentials through the Daily Press Galleries must establish to the satisfaction of the Standing Committee of Correspondence that he or she is a full-time, paid correspondent who requires on-site access to congressional members and staff. Correspondents must be employed by a news organization, A, with general publication periodicals mailing privileges under U.S. Postal Service rules, and which publishes daily, or B, whose principal business is the daily dissemination of original news and opinion of interest to a broad segment of the public, and which has published continuously for 18 months. The applicant must reside in the Washington, D.C. area, and must not be engaged in any lobbying or paid advocacy, advertising, publicity or promotion work for any individual, political party, corporation, organization, or agency of the U.S. government, or in prosecuting any claim before Congress or any federal government department, and will not do so while a member of the Daily Press Galleries. Applicants' publications must be editorially independent of any institution, foundation, or interest group that lobbies the federal government, or that is not principally a general news organization. Failure to provide information to the Standing Committee for this determination, or misrepresenting information, can result in the denial or revocation of credentials. Rec. And judicial notice. X. E. U.S. Senate Daily Press Gallery. Governing of Rules. ECF number 24-6. Senate Daily Press Gallery Rules. See U.S. House Periodical Press Gallery. Rules. And Regulations. Periodical.house.gov web link. House Periodical Press Gallery Rules. Similar. 2 CDFs. Risk. 2PL.S Fax Pilcro 17-19. The effect of White House policy changes on July 11, 2023. The received a reprimand letter pursuant to the new conduct policy. PL.S risk. TDFs. Fax Bill Crow 12. The letter outlined 4 instances when he disrupted press briefings and afforded him an opportunity to respond to the allegations. Compel, X. B. ECF number 1-2. Reprimand letter. Detailing incidents on May 13, 2022, December 8, 2022, March 20, 2023, and June 26, 2023. While the letter contained a warning that discontinued disruptions could result in the suspension or revocation of his hard pass, the White House did not revoke his hard pass pursuant to the conduct policy. Id. CPL.S risk. TDFs. Fax Bill Crow 12. On August 1, 2023, the White House directed the Secret Service to deactivate hard passes for approximately 500 journalists who did not qualify under the new hard pass policy. PL.S risk. TDFs. Fax Bill Crow 14. 2. has submitted an unopposed motion for the court to take judicial notice of the following documents. 1. Brief of the White House correspondent Sasson as amicus curiae sup. Appellee, Karam v. Trump, case no. 19 to 5255, D.C. January 13, 2020, ECF number 24-2. 2. Transcript of oral decision, CNN v. Trump, 1:18 CVO 2610 TJK, at 7:19 to 22, DDC November 16, 2018, ECF number 24-3. 3. Congressional News Media and the House and Senate Press Galleries, Congressional Research Service, April 13, 2017, ECF number 24-4, at 4. 4. Periodical Press Gallery, Accreditation, House Periodical Press Gallery, ECF number 24-5, and 5. Senate Daily Press Gallery Rules. Rec. And judicial notice, ECF number 24. The court may take judicial notice of facts not subject to reasonable dispute that are generally known within the trial court's territorial jurisdiction and can be accurately and readily determined from sources whose accuracy cannot reasonably be questioned. Fed. RFID. 201B. The motion is granted to the extent the facts are relied upon in this opinion. The court also takes judicial notice of the rules of the House Periodical Press Gallery, since the has already pointed the court to another part of that gallery's accreditation procedures. Because the raises a facial challenge to the policy, it is appropriate for the court to consider different rules under which a journalist can obtain a credential. To elect a credential from the Supreme Court or one of the Congressional Press Galleries, as required under Rule number 5 of the Hard Pass policy, and his hard pass was deactivated. It applied for a credential from the Senate Daily Press Gallery on June 5, 2023.
They drew these rules up so they can draw him just outside these rules.
ECF number 1-3. Letter to Senate Daily
The
Press
press
Gallery.
secretary just ignored him the whole time, never let him ask questions, and then does this because she didn't like the questions he was asking. It's ridiculous.
CPL.S Fax Bill Pro 18 to 19.
It is.
But did not apply to renew his hard pass before it was deactivated. CPL.S risk. TDFs.
It's hard to watch.
It has continued to access the press area with a day pass. Id. Pilcrow
It
15,
really is.
C3D Fleischer-Dickel.
He's got good
Pilcrow 17,
questions.
stating that, since his
Yeah.
hard pass was deactivated, he has been granted day pass access to the White House each time he sought it, and that he has entered the White House on several of those occasions. 2. Procedural background. On August 10, 2023, sued White House Press Secretary Karine Jean-Pierre, in her official capacity, as well as Director of the United States Secret Service Kimberly Cheadle, in her official capacity, and the United States Secret Service. Compel. Pilcrow 19 to 21. Simultaneously moved for a preliminary injunction to enjoin the hard pass policy and restore his hard pass. PL.SMO. For prelim. Inch. ECF number 2. Ateba makes 3 principal claims. First, he alleges that the hard pass policy violates the First Amendment on its face, because it confers unbridled discretion on the Congressional Press Gallery Committees to determine who can obtain a hard pass. Count 1. Compel. Pilcrow 83 to 89. Second, he alleges that the White House discriminated against him based on his viewpoints by adopting hard pass policy criteria specifically designed to exclude him from eligibility. Count 2. Id. Pilcrow 90 to 95. And third, alleges the Secret Service violated the Administrative Procedure Act, APA, by deactivating his hard pass without reasoned explanation. Count 3. Id. Pilcrow 96 to 103. The court denied his motion for a preliminary injunction, concluding that Ateba had failed to show he was likely to suffer irreparable harm during the pendency of this litigation. V. Jean-Pierre, Civ. A number 23 to 2321, JDB, 2023 WL 5,748,567, at 1, DDC September 6, 2023. The court concluded based on the facts presented that he remained able to enter the White House using the day pass system, which the court found was an acceptable alternative for the duration of the litigation. At 4. However, so that the merits of this challenge could be swiftly adjudicated, the court ordered the parties to submit summary judgment briefing on an expedited schedule. At 1, 6. The White House submitted a motion for summary judgment on all 3 counts. Leaves. Mo. Submitted a cross motion for summary judgment on the facial First Amendment challenge and the APA challenge. PL.S combined mem. In sub. Of some. J and open to Deefs. Mo. For some. J. ECF number 23. PL.S cross mo. And open. But also asked the court to deny the White House's motion for summary judgment on the viewpoint discrimination challenge and order discovery from the White House. The court held an oral argument hearing on the summary judgment motions on November 2, 2023. The motions are now fully briefed and ripe for decision. Legal standard: a movement is entitled to summary judgment if he can show that there is no genuine dispute as to any material fact, and the movement is entitled to judgment as a matter of law. Fed. RCiv. P. 56A. At the summary judgment stage, the court must examine the facts in the record and all reasonable inferences derived therefrom in a light most favorable to the non-moving party. Robinson v. Pezat, 818 F.3D1, 8, DC 2016, internal quotation marks omitted. This mode of analysis serves to separate the jury functions of making credibility determinations, weighing the evidence, and drawing legitimate inferences from the facts from the district court's role as the arbiter of legal questions. Cleaned up. When parties file cross motions for summary judgment, each motion is viewed separately, in the light most favorable to the non-moving party, with the court determining, for each side, whether the Rule 56 standard has been met. Lurk Bates Incorporated v. Michael Blades and Essex, Limited, Civ. A number 20 to 2223, BAH, 2023 WL 6,276,643, at 9, DDC September 26, 2023. Analysis: I. First Amendment injury. The White House claims that Ms. First Amendment challenges cannot get off the ground because he has not suffered a cognizable First Amendment injury. Leaves. Mo. At 6. According to the White House, since Ateba has not lost access to the White House press briefings, only expedited hard pass access, he has suffered a mere inconvenience, not a violation of his First Amendment rights. C. Leaves. Combined open to PL.S Mo. For some. J. And reply in sub. Of Leaves. Mo. For some. J. ECF number 26. Leaves. Reply and open. At 1 to 3. The court considers this argument relevant to Atebas facial challenge and his viewpoint discrimination claim. 3. Generally, the First Amendment does not provide journalists any greater right of access to government property or information than it provides to members of the public, despite the fact that access to government information might lead to more thorough or better reporting. JB Pictures. 3. At oral argument, counsel for the White House acknowledged that this argument, while described as a challenge to Ateba's injury, does not attack his constitutional standing. Nor could it. Ateba is plainly injured by losing the hard pass, which provided him expedited access to the White House briefing room. C. Flint v. Rumsfeld, 355F.3D 697, 702, DC 2004. Appellants had standing where they sought and were denied access to accompany U.S. troops in combat. See also Zuckerman v. U.S. Postal Serve, 567F sub. 3D 161, 170-71, DDC 2021. F4 Article 3. Standing purposes at least, the required threshold is quite low. The loss of the hard pass is traceable to actions of the White House and the Secret Service, and his injury can be redressed by an order that the defendants reconsider the hard pass policy or reinstate his hard pass. Incorporated v. of Def. 86F.3D 236, 238, DC 1996. C. Brandsburg v. Hayes, 408 U.S. 665, 684, 1972. As it pertains to the press, the First Amendment primarily protects the right to communicate information once it is obtained, not the ability to collect it. Hawkins v. KQED Incorporated, 438 U.S. 1, 9, 1978, plurality opinion. Hence, courts have generally refused to find that the First Amendment requires government entities to admit press into places not otherwise open to the public, provide enhanced access to information under the government's control, or afford journalists heightened access to places open to the general public. See, for example, L.A. Police v. United Reporting Public Corps, 528 U.S. 32, 40, 1999. California could decide not to give addressee information at all without violating the First Amendment. Hawkins, 438 U.S. at 16. TV media have no special right of access to a jail, different from or greater than that accorded the public generally. Flint v. Rumsfeld, 355F.3D 697, 703, DC 2004. No First Amendment right for press to travel with the military during combat. JB Pictures. 86 F.3D at 242. No First Amendment right for media to attend military funerals. The First Amendment may, however, provide some protections when journalists are denied access to areas the government has specifically opened to the press. The D.C. Circuit has read the First and Fifth Amendments together to prohibit the denial of a journalist's access to the White House press area without due process protections. Cheryl, 569 F.2D at 129-31, Garum, 960 F.3D at 664-67. This court has, correspondingly, concluded that the First and Fifth Amendments seem to require, at a minimum, that before determining which media organizations receive the limited access available, a government agency must not only have some criteria to guide its determinations, but must have a reasonable way of assessing whether the criteria are met. Getty Images News serves. Core. V. Of Def. 193 F sub. 2D 112, 121, DDC 2002. Thus, where the Department of Defense lacked an articulated process for deciding which journalists could participate in the military's media flights to Guantanamo Bay in the wake of September 11th, the plaintiffs had a cognizable injury under the First and Fifth Amendments. While the D.C. Circuit did not reach this question in Karam, the court reads Cheryl to support a First Amendment claim at least when the journalist is excluded from the press area for arbitrary reasons. As the Cheryl court stated, White House press facilities having been made publicly available as a source of information for newsmen, the protection afforded news gathering under the First Amendment guarantee of freedom of the press requires that this access not be denied arbitrarily or for less than compelling reasons. Cheryl, 569 F.2D at 129, internal citations and footnote amendment. The White House's contention that Cheryl is a due process case, despite its First Amendment
I'm eager to see what his appeal looks like. I don't think it's actually filed, it's just a notice of appeal.
Although that court ultimately focused on the Secret Service's need to formalize security standards and provide applicants notice and an opportunity to respond to denials, the court first considered whether the standard articulated by the Secret Service in litigation, whether the applicant presents a potential source of physical danger to the president and or his immediate family so serious as to justify his exclusion comported with the First Amendment. Cheryl, 569 F.2D at 130, footnote omitted. Recent cases in other circuits have accepted the premise that the denial of a reporter's access to a press briefing is a cognizable First Amendment violation, reviewable in the traditional framework of a First Amendment forum and subject to an order requiring not only due process, but access. See John K. Meek-Everest. For Pub. Holy v. Evers, 994 F.3D 602, 610, 7th. 2021, reviewing criteria to access a media briefing under a First Amendment analysis for reasonableness and viewpoint neutrality, TGP Comms, LLCV. Sellers, number 22 to 16,826, 2022 WL 17,484,331, at 4 to 5, 9. December 5, 2022, same, CF. Humansky v. Corsons, 396 F.3D 53, 88, 2D. 2005, exclusion of individual journalists from all state courthouses otherwise open to press was plainly overbroad and not tailored to the threat. Nicholas v. Braden, 376 F sub. 3D 232, 259 to 60, SDNY 2019, reviewing journalists' equal access claim to crime scene under the First Amendment. Unlike the prior cases involving restrictions on White House access, however, this case does not concern a denial of access to the press area. Ateba has lost his hard pass, but he can still access the press area with a day pass. Accordingly, Ateba asks the court to find his access to the press area has been burdened by the loss of his hard pass, and that this burden constitutes a First Amendment injury. PL.S. Crossmo. And Opinat 17 to 18.4 the D.C. Circuit has not considered whether denial of a hard pass, when the reporter can still access the press area with a day pass, amounts to a First Amendment injury. See Cheryl, 569 F.2D at 130, noting that denial of hard pass resulted in exclusion. From White House press facilities, Garum, 960 F.3D at 665, describing sanction as a month-long loss of White House access. Neither party has cited any case directly addressing whether a burden on access to the press area, or any similar press area, for that matter, constitutes a First Amendment injury. But urges the court to rely on the general principle that governmental action that burdens First Amendment activity inflicts a cognizable injury no less than governmental action that prohibits such activity outright. PL.SMO. And Opinat 17, quoting Sorrell v. IMS Health Incorporated, 564 U.S. 552, 566, 2011, citing, inter alia, United States v. Playboy Int. GRP, 529 U.S. 803, 812, 2000, limitations on television programming time, and Minneapolis Star and Trib. Company v. Minnesota Commerce Revenue, 460 U.S. 575, 582 to 83, 1983, tax on the press. The White House counters that Ford also claims that loss of the hard pass itself is a cognizable injury under the First Amendment under Cheryl and Karam. PL.S. Crossmo. And Opinat 17 to 18. While those cases recognized a right in the past, the loss of the hard pass there was inextricably tied to the complete loss of access. Only burdens on the freedom of the media to communicate information are actionable, not burdens on obtaining information from the government. Leaves. Reply and Opinat 2, quoting Hawkins, 438 U.S. at 9, see Hawkins, 438 U.S. at 4 to 5. No First Amendment violation when news reporters were given only limited access to the jail on public tours that did not reach area of alleged prisoner abuse. Zimmel v. Rusk, 381 U.S. 1, 17, 1965. That, the prohibition of unauthorized entry into the White House diminishes the citizens' opportunities to gather information. Does not make entry into the White House a First Amendment right. Cf. ACLU of MD. V. Y comico CNTY, 999 F.2 D 780, 786, 4th. 1993, County did not engage in First Amendment retaliation by revoking an ACLU paralegal's special inmate access due to the ACLU's lawsuit against the jail. However, Ateba argues elsewhere, his participation in press conferences is arguably expressive. Because he speaks through his questions, broadcast on live television, which
I was saying that, this isn't a jail we're talking about, it's the White House, thank you, Harsh.
And Opinat 8, even burdens on
It's
his
the
access
White House
to
press
the
pool.
his right to communicate information,
And this
not only his right to correct it.
absolutely
As an initial matter,
raises
the undisputed fact,
concerns,
and inference that his
First
access to the
Amendment
press area has been denied.
concerns.
It is undisputed that a day pass
And it
holder
should
may
be
access the same parts of the
scrutinized.
White House at the same time as
It's
a hard
not
pass holder.
jail. It's not a
And once
military
journalist reaches the press
funeral.
area, a day pass holder is not subject to any restrictions that
Or
would not also
war.
apply to a hard pass holder.
I mean,
If
this
a day pass
room was
holder misses
built
a
for the
spontaneous
press.
deletion, that is because he or she did not apply for a day pass, not because he or she has been excluded from the press area. No facts in the record suggest otherwise. That, for example, seats in the press area are reserved for hard pass holders, that day pass holders cannot bring in cameras, or that certain events or places are open to hard pass holders only. This case is, therefore, unlike Stevens v. in Y Racing Assen, 665 F. Sup. 164, E.D. New York 1987, where the court found actionable a restriction prohibiting one journalist from entering a racetrack with a camera, while all other journalists were permitted to do so. Id. At 175. However, the undisputed facts also demonstrate that being required to use a day pass instead of a hard pass burdens this press area access to some degree. Put differently, the facts in the record support an inference that a hard pass is a preferred form of access to a day pass. Whereas a hard pass holder can enter the White House at a moment's notice, other journalists must apply for a day pass up to a day in advance. Thus, a journalist who does not prophylactically apply for day passes might miss a late scheduled press event. And while a hard pass holder can walk directly inside after security screening, a day pass holder must wait on an escort, which can take up to 45 minutes depending on when the journalist arrives. Perhaps it is on account of these differences
can't
or changes
sustain
in the
that
White House day
long-term
pass policy over time
as a
that the White House
journalist covering the White
Correspondents
House.
Association has remarked in previous litigation that without the access that a hard pass grants, a White House correspondent cannot effectively perform his or her duties, which include providing the public with on-the-spot news coverage of unforeseen and unscheduled events, along with cataloging the daily activities of the head of the executive branch. Rec. 4. Judicial Notice. X. A. Brief of the White House Correspondence as amicus curiae E. Supporting appellee at 3. Karam v. Trump. Number 19 to 5255. D.C. January 13, 2020. Ultimately, the court concludes that Ateba has an actionable First Amendment injury. As the D.C. Circuit recognized in Sherrill, the White House has opened the press area to journalists who need to report therefrom. 569 F.2d at 129. Although that case preceded modern-day form analysis, the Sherrill Court's characterization of the press area is akin to that of a First Amendment form government property that public officials have open to certain members of the public for certain types of communication. Here, news gathering. Other circuits have similarly treated press briefings as First Amendment forums. See Evers, 994 F.3d at 610, TGP Comms, 2022. WL 17,484,331, at 4 to 5. Accordingly, in deciding whether an injury exists, the court must consider principally whether a burden on access to a First Amendment forum would amount to an injury. Even in a non-public forum, where government authority to restrict access is at its apex, a plaintiff has an actionable claim when the government has allegedly discriminated with respect to who may use its facilities and on what terms. G. Acorn v. Metro. Peer and Exposition of 150 F.3d 695, 700, 7th, 1998, emphasis added, finding actionable government agencies. Disparate waiver of fees for use of meeting rooms, where the White House press facilities are perceived as being open to all bona fide Washington-based journalists. Sherrill, 569 F.2d at 129. Footnote omitted. Disparate forms of access to that forum are likewise actionable under the First Amendment. This is not a case, as the government urges, where a member of the press seeks greater access, or better terms, than members of the public. See Hawkins, 438 U.S. at 4 to 5. Nor is it a case about journalists seeking information in the government's possession. See LA Police, 528 U.S. at 40. Rather, this case involves a journalist seeking access to a forum opened by the White House, on the same terms as other journalists. To conclude that only outright denials of access are actionable would undermine the protections established by Sherrill, for it would suggest that the White House could alter the hard pass criteria, and thereby impose disparate burdens on journalists seeking access to a place generally open to them, in entirely viewpoint discriminatory ways, and journalists would have no cause of action. Counsel for the White House admitted as much at oral argument. Oral argument ref HR GTR, 35 to 2 to 16, agreeing that under the court's hypothetical policy granting hard passes only to partisan news organizations, a journalist would have no cause of action. That is not to say that every restriction the White House might impose on access to the White House violates the First Amendment.
The speaking aspect here, and start it back up. It was kind of getting a little broken up there, and I think maybe it's because it's been working. Even the computer needs to take a break for a second. Let's start it back up, and maybe I think it should be a little bit smoother.
Simon Plaintiff.
Oh no!
Civil action number 23 to 2321. JDB. Karine
I
Jean-Pierre.
screwed this up, huh? And I think we were... Oh, this is... Where are we? I can tell in my live. And if you just bear with me here, Hoochins 38. And 438. We're almost back to where we were. There. Let me try again here. Bear with me. 1 minute delay. Ain't nothing. All right. Speak selected text.
C. Hawkins,
There we go,
438 U.S.
Hawkins.
F 4 to 5. Nor is it a case about journalists seeking information in the government's possession. C. L.A. Police 528 U.S. F 40. Rather, this case involves a journalist seeking access to a form opened by the White House on the same terms as
Josh, I
other
haven't
journalists.
been.
To conclude
I
that the
haven't
outright
been.
denials of access are actionable when undermine the protections established by Cheryl, for it would suggest that the White House could alter the hard pass criteria and thereby impose disparate burdens on journalists seeking access to a place generally open to them in entirely viewpoint discriminatory ways, and journalists would have
Right,
no cause
that's
of
what
action.
the
Counsel for the
that's
White
what
House
the courts are reasoning
admitted as much at
here,
oral
it
argument.
seems like.
Oral argument
Even
by
though
Faye
they
charges
recognized early on,
32 to 16,
sorry,
agreeing that under
that he has
the court's hypothetical policy
some
granting hard
First
passes only to
Amendment
partisan
injury.
news organizations. A.
I mean, here's the
Journalist
problem
would have
for
no cause of
me.
action.
It just doesn't
That
pass
is
the
not to say
sniff
that every
test. Something
restriction the White
about
House
it
might impose
really
on access to
bothers
the
me.
White House violates the First Amendment. Indeed, the court will conclude in this case that the hard pass policy does not facially violate the First Amendment. However, it does mean that regulations as to who may obtain a hard pass, even when a day pass is available, are subject to First Amendment scrutiny. As the court will discuss below, when the White House decide who gets expedited access and who does not, its regulations must be reasonable and viewpoint neutral. 2. Facial
I
challenge
guess
to
the
hard
law
pass
doesn't
policy.
care about my
Claims
feelings,
the
but
hard
there
pass
is
policy
something
facially violates the
about
First Amendment because the policy
your
is
gut
unreasonable
just
and
knowing
confers unbridled
this
discretion
isn't
on
right.
press galleries who supply the requisite credentials for obtaining a hard pass. The court concludes that the policy is reasonable, and that discretion is sufficiently cabined to satisfy the First Amendment. A. Legal standards. When considering the amount of access to which the government must give the public. For First Amendment
Oh no, you're
activities,
following
courts
it,
generally
Matt.
apply form
Yeah,
analysis.
you got
Evers,
right on the money.
994 F.3d at 609. In a form analysis, a court classifies the government property by type of form, i.e., public, designated public, limited public, or non-public, and applies the appropriate standard to evaluate the constitutionality of limitations on the First Amendment activity. Id. 5 courts have the least tolerance for
There's
restrictions on
certain
First Amendment
levels of
freedom in public
scrutiny
forums.
depending on
Id.
why you're
Cases where
discriminating somebody.
people
You
have
can,
historically assembled
based
and
on
communicated with others,
gender,
by
race,
the
or
White House argues
age.
that
Those
the
are all
president does not
different
lend itself to
levels of
form analysis
scrutiny.
at all. Citing Price v. Garland, 45F.4th 1059, D.C.
And there's also time and
2022.
place
In Price, the
restrictions.
D.C. Circuit declined to apply the heightened protections of a public forum to commercial filmmaking in a national park, since filmmaking, like typing a manuscript, is not itself a communicative activity. Id. At 1070. This argument misses the mark because participation in a news conference is expressive, since reporters communicate with White House staff and raise issues of public importance to the president and his team. C. Evers, 994 F.3d at 611 to 12, TGP Comms, 2022 WL 17484331, at 4, CF. Price, 45. F.4 TH at 1071 M.2, distinguishing Evers because it does not even deal with filming but rather applied form analysis to gathering information for news dissemination. Quoting Evers, 994 F.3d at 612. Government has intentionally opened for that purpose. Price v. Garland, 45 F.4 TH 1059, 1067 to 68. DC 2022. In public forums, regulations based on the content of speech are subject to strict scrutiny. They must be necessary to serve a compelling state interest and narrowly drawn to achieve that end. Perry I. Duck. Assen v. Perry Locke. Educators Assen, 460 U.S. 37, 45, 1983. Content neutral time, place and manner restrictions in public forums.
Yeah, it does.
Scrutiny. They
So,
must be narrowly
yes.
tailored to serve a significant government interest.
It really
Id.
seems like the
At
court
45
is
to
doing
46.
that a lot these
The government
days,
has
too.
more latitude when regulating access to non-public and
Really
limited public forums,
reaching.
i.e., places not open to public communication, or limited to use by certain groups or dedicated solely to the discussion of certain subjects. Price, 45 F.4 TH at 1068, quoting Pleasant Grove City. V. Summum, 555 U.S. 460, 470, 2009. In a non-public or limited public forum, government regulations need only be viewpoint neutral and reasonable given the purpose of the forum and all the surrounding circumstances. Id. Internal quotation marks omitted. 6. The parties dispute whether the press area is a non-public or limited public forum. The White House contends
Isn't
the press
that
area
nuts?
is a non-public forum because access is selective and limited to those who satisfy the 6 criteria or are otherwise invited. The White House has not generally opened its grounds to all comers or even to all journalists. Leaves. Mo. At 8. 6. But also contends that Cheryl offers a test for evaluating the constitutionality of press pass restrictions. PL. Crossmo. And Oppen at 5 to 7.
We're almost, well,
Specifically,
we're halfway
people with
done
language
with
in
the
Cheryl stating
opinion
that
here.
access should not be denied arbitrarily or for less than compelling reasons. Cheryl, 569 F.2d at 129, CED. At 130, our refusal must be based on a compelling governmental interest. The White House contests this assertion that Cheryl dictates any standard under the
Right,
First
I
Amendment.
think he's being
Leaves.
sarcastic
Reply, Oppen
or
at 9.
facetious.
Since Cheryl preceded modern form analysis, it is
I
difficult
mean,
to
Josh
ascertain
says what
precise legal
he's
equivalent.
says
but
what
the
he's thinking.
term compelling need not, and should not, be taken to suggest the application of a strict scrutiny standard, nor does but ask the court to apply strict scrutiny.
Yeah.
Rather, when the Cheryl court briefly addressed the adequacy of the Secret Service's substantive standard for regulating access to the White House, whether the applicant's presence a
And I
potential source of
appreciate
physical
it 'cause
danger to the
they're tough
president and or his immediate family so
observations, and I-
serious as to
you know.
justify his exclusion. The court acknowledged the standard was circumspect and allowed the Secret Service to exercise expert judgment which frequently must be subjective in nature. Id. The latitude afforded the Secret Service suggested a standard similar to reasonableness. Accordingly, the court finds review under the reasonableness standard of form analysis appropriate even under Sherrill. Responds that the press area is a limited public forum because, by long practice, the White House created and has operated the press area for the purpose of allowing journalists access to the White House to communicate with the President and his staff and to gather and disseminate the news. PL.S. Cross Mo. And op in at date. The parties' positions on this point are at odds with their arguments. Elsewhere in the litigation, where the White House contends elsewhere that access is available to any journalist who can pass a minimal Secret Service screening, i.e., eligible for a day pass, here. The White House suggests access is open only to hard pass holders or invited guests. Elsewhere suggests that a journalist cannot effectively access the press area without a hard pass. But here he contends the area is open to all journalists for reporting. Ultimately,
it's like,
the court may not wade through the parties' internal inconsistencies. Since
these
regardless
lower
of the type of format
courts
issue, non-public or
been
limited public,
packed
the standard of review is the same,
with
whether a challenge
judges who are,
limitation is reasonable and viewpoint neutral. CACLU
I think the activist judge is the term.
303 F sub.
Thank God
17,
there's an appellate
DDC
process.
2018. In a non-public or limited public forum, the state, no less than a private owner of property, has power to preserve the property under its control for the use to which it is lawfully dedicated. Periaduc. Essen, 460 U.S. at 46. In addition to time, place, and manner regulations, the state may reserve the forum for its intended purposes, communicative or otherwise. Thus, in such forums, the government may draw distinctions based on subject matter and speaker identity so long as the distinctions drawn are reasonable in light of the purpose served by the forum and are viewpoint neutral. Cornelius v. In AACP Legal Def. And Educ. Fund, 473 U.S. 788, 806, 1985. Although a speaker may be excluded from a non-public forum if he wishes to address a topic not encompassed within the purpose of the forum, or if he is not a member of the class of speakers for whose especial benefit the forum was created, the government violates the First Amendment when it denies access to a speaker solely to suppress the point of view he espouses on an otherwise includable subject. Internal citations omitted. See Christian Legal Saki Chapter of University of California, Hastings College of L. V. Martinez, 561 U.S. 661, 682-82, 2010, discussing parallel characteristics of a limited public forum. Reasonableness requires something more than the toothless rational basis test used to review the typical exercise of a state's police power. Price, 45F.4th at 1072. However, a regulation can be reasonable without being the most reasonable or the only reasonable limitation. Cornelius, 473 U.S. at 808.
If
A court must
Ateba
assess
starts
limitations in light of
dressing up
purpose
in
of the forum.
women's clothing, he
And
would
all
get a
the surrounding
hard pass then,
circumstances.
yes.
At 809.
Probably.
The First Amendment does not demand unrestricted access to a non-public
It's
forum merely
hilarious
because use of that
true.
forum may be the most efficient means of delivering the speaker's message. In contrast to a public forum, a finding of strict incompatibility between the nature of the speech or the
Where
identity
my
of the speaker
country
and the
gone?
functioning of the non-public forum is not mandated. At 808. The reasonableness of a limitation can be established by evidence in the record or even by common sense inference. Price, 45F.4th at 1072. The parties dispute whether a reasonableness analysis incorporates the doctrine of unbridled discretion.
Exactly,
That doctrine emerged in the
Josh.
context of prior restraints on expressive activity, i.e., government rules prohibiting individual expression without a license. See Forsyth County v. Nationalist Movement, 505 U.S. 123, 130-31, opening parenthesis 1992, closing parenthesis, opening parenthesis, public demonstration
Strange
committee, closing
times we're
parenthesis,
living in.
City of Lakewood v. Plain Dealer Public Co., 486 U.S. 750, 753, 763-64, 1988, newsstand licensing. The Supreme Court has allowed facial challenges and even invalidated challenged regulations when they provide overly broad licensing discretion to the administrator. City of Lakewood, 486 U.S. at 764, quoting Freeman v. State of Maryland, 380 U.S. 51, 56, 1965. The court has stated that narrow, objective, and definite standards are needed to guide licensing authority. Forsyth County, 505 U.S. at 131, quoting Shuttlesworth v. Birmingham, 394 U.S. 147, 150 to 151, 1969. The doctrine seeks to reduce the risk of self-censorship by speakers hoping to obtain a necessary license, and the risk that the licensing official, not limited by express standards, will use his power to suppress speech. Southworth v. B.D. of Regents of University of Wisconsin Sys, 307 F.3D 566, 576, 7th, 2002, discussing City of Lakewood, 486 U.S. at 757 to 58. As a secondary component of the doctrine, the Supreme Court has sometimes required officials to abide by certain procedural safeguards, including expeditious judicial review and timelines for decision-making. Thomas v. G. Park Dist, 534 U.S. 316, 321 to 22, 2002. The White House contends that the unbridled discretion doctrine does not apply to access to the press area, a non-public or limited public forum, claiming that the Supreme Court silently rejected the application of the unbridled discretion doctrine to non-public forums by refusing to embrace the plaintiff's argument in Arkansas Educational Television Commission v. Forbes, 523, U.S. 666, 1998. CDFs. Mo. At 9 to 10. However, as the points out, the Supreme Court has extended at least some of the protections of the unbridled discretion doctrine to non-public forums.
Yeah, I'm not sure where the
CPL.
court's going. It seemed to
and
support
Auburn
Simon.
14. In Minnesota Voters Alliance v. Mansky, 138 South Court 1876, 2018.
They're saying it
The
doesn't
court held that
apply
Minnesota
here.
law banning political apparel in a non-public forum, the polling place, was unreasonable because it contained no objective, workable standards. Id. At 1891, Ced. At 1888. Although the state had a legitimate goal of creating an island of calm in which voters can peacefully contemplate their choices, id. At 1887, internal quotation marks omitted. It needed a standard that articulated some sensible basis for distinguishing what may come in from what must stay out, id. At 1888. The D.C. Circuit has since distilled unbridled discretion and the Mansky rule to a single challenge, whether a regulation is so broad as to provide the government with no meaningful constraint upon its exercise of the power to squelch. If so, then it is not reasonable, as that term is used in Mansky, and not constitutional
That's
because it provides
Mansky,
the
not
government
Minsky.
with unbridled discretion. But the other way around,
Whose name
if
we
the
saw
regulation
a
is capable
lot
of
during
reasoned
the
application,
Epstein
as
times.
Mansky demands, then it does not confer unbridled discretion upon the government. Am. Freedom Dev. Initiative V. Washington Metro. Area Transit Off. AFD 901 F.3D 356 372 DC 2018 Accord Zuckerman v. U.S. Postal Serve 961 F.3D 431 449 DC 2020. The White House urges the court to read this principle narrowly, arguing that the cases from which it emerged concern core First Amendment activity, the expression of ideas, beliefs. Reply and op in at 6, not the distinct context of journalist access to what is, at most, a non-public form, beliefs. Mo. At 10. But such a limitation is not warranted here. While the press may not challenge every law involving discretion as censorship, the press may challenge those laws having a close enough nexus to expression, or to conduct commonly associated with expression, to pose a real and substantial threat of the identified censorship risks. City of Lakewood, 486 U.S. at 759. White House press conferences involve a communicative exchange between the government and news reporters. As journalists ask questions, they raise issues important to their readers, and foster public discussion of the president's administration. CPL.S Crossmo. And op in at 8. Other circuits have likewise recognized that participating in press conferences has a nexus to expression. See Evers, 994 F.3D at 611-12, characterizing gathering information for news dissemination as a form of expressive activity. TGP Comms, 2022 WL 17,484,331, at 4, describing news conference as a place for speech on limited topics. Moreover, the purposes of the unbridled discretion doctrine would be served by its application to White House press access. CPL.S Crossmo. And op in at 14. A rule limiting press access without objective, workable standards could encourage journalists to self-censor to obtain access, and shelter decision-makers from accountability if they excluded reporters based on their comments. Cf. Panam. Center v. Trump, 448 F. Sup. 3D 309, 326-27, SDNY 2019. Concluding journalists adequately pleaded retaliation claim based on credential revocation after speaking critically of former President Trump. Accordingly, the court will take account of the unbridled discretion doctrine in reviewing the hard pass policy for reasonableness and viewpoint neutrality. The reasonableness review as an initial matter. Neither party argues that the press
I don't
credentialing
know if
requirement is
anybody's
itself viewpoint
watching the
discriminatory.
Iowa
Rather, but
of it
argues that
all.
the requirement of credentialing by the press galleries is
You
arbitrary
have
and unreasonable.
all the
The White House
candidates
asserts that
running
the
away
Treasury has
from
legitimate interest in
Laura
maintaining a degree of
Loomer,
control over media
who's
access to the White House complex. Beliefs.
very
No.
hardcore Trump
At 11,
supporter.
quoting Karam, 960 F.3D at 668, given the purpose of White House briefings and the limits that must exist, for reasons of security and government efficiency, on access to the White House, id. The White House further argues that, implicit in that interest is the ability to limit the press areas to those engaged in journalism, id. The requirement of credentialing by an outside professional organization, it contends, is a reasonable way to do so, id. But concedes that limiting press area access to those engaged in
Yeah,
journalism is a legitimate reason
MSNBC
for requiring press
questions
credentials.
only.
PL.S Crossmo. And
What
Alvin
was
at
that
15.
last
However, he
lady's
argues that the
name?
requirement of credentialing by the congressional press galleries is unreasonable for two principal reasons. First, because the gallery credentialing requirement is standardless and susceptible to abuse.
Is Jen
At
Psaki,
10,
right?
and second, that requiring a press gallery credential lacks a rational nexus with the government's compelling reason for
And
the
she
restriction.
has a show
given
on
that
MSNBC
journalists
now.
covering the White House might not want to cover Congress, id. At 15,
Inside
the White
with
House
Jen
has long relied on
Psaki.
credentialing by the congressional press galleries as a prerequisite to obtaining a press credential.
Complete
See Cheryl,
propaganda.
569 F.2D at 129 N.19.
It looks like
noting the requirement in
propaganda.
1977, Garam, 960 F.3D at 660, same in 2020, CED. 40 years on, from Cheryl, today's hard pass system is little changed, and the requirements for credentialing by the press galleries are functionally the same as they were around the time of Cheryl, including the requirement that journalists be bona fide reporters of reputable standing. See Consumers. Union of U.S. 515 F.2D at 1344-45, quoting rules governing periodical press galleries in 1975. While not passing directly on the question, the D.C. Circuit has never questioned the requirement of press credentialing or the substance of the standards. And as the White House points out, it is commonplace for government entities to rely on professional credentialing bodies as a means of determining access. CDFs. Mo. At 11, citing examples. The standards that the press galleries apply are also directly related to determining whether an applicant is engaged in journalism, and not a lobbyist or investor seeking to influence or
It's not Hunter
the right benefit
Biden.
from access to government officials. CDFs. Reply and op in at 10, contending that the credentials are a reasonable heuristic for identifying bona fide journalists and ensuring the White House press areas are properly limited to those genuinely engaged in journalistic pursuits. Indeed, the rules of the Senate Daily Press Gallery, to which the has sought access, require that the applicant be employed by a news organization whose principal business is the daily dissemination of original news and opinion of interest to a broad segment of the public, and which has published continuously for 18 months,
Where are they
and which
going
is
here?
editorially independent of any institution, foundation, or interest group that lobbies the federal government. Senate Daily Press Gallery rules. Further, the applicant must not be engaged in any lobbying or paid advocacy, including before Congress or any part of the federal government. Id. With narrow focus on the allegedly standardless and susceptible to abuse requirement that an applicant be a bona fide resident correspondent of repute in their profession, PL.S Crossmo. And op in at 10 removes the important context of the credentialing rules. while the court does not undertake to offer a binding or limiting definition of the term of repute as used in the press credentialing rules, it is apparent that the term at least draws meaning from the rules that follow. See Senate Daily Press Gallery Rules. Unlike in McDaniel v. Lombardi, 227 F Sup. 3D. 1032, W. Demo. 2016, where selection of
It's
execution
almost
witnesses
like I've
is based
seen
on the
enough, but I do want to
requirement that the
finish
individual be
this.
reputable in the warden's point of view.
Just in
It,
case.
At 1034, 1038 to 39.
They make a good point.
The standard here is followed by detailed regulations suggesting a more definite meaning. Differentiating who may come in from, who must stay out. Mansky, 138 South Court of 1888. The term of repute derives meaning from the central tenets of the regulations, that the person is working as a journalist for an established news organization and that the person does not have any conflicts of interest. 7. While not
I
directly
was
considering the
just
additional principle of
thinking
unbridled
this. I
discretion,
almost
the Seventh
tweeted it out. It's
Circuit has
like,
concluded
there
that a very
are
similar set of rules
no
adapted from established
journalists.
standards
There's
used
like
by
two.
the United States Congress and including the requirement
No
that a journalist
journalists
be a bona
left.
fide
There's propagandists.
correspondent of repute in their profession was a reasonable means for the Wisconsin governor to determine access to press conferences. Evers, 994 F.3D at 606-207, 610-11. The court.
I don't know. It seems like they're heading in that direction.
7. The additional rules governing eligibility for press credentials also tend to foreclose this argument that
Here we go.
reputable is a transparent classification among journalists in favor of the institutional press. PL.S. Crossmo. And Oppen at 16, citing Citizens United v. Fed. Election Common, 558 U.S. 310, 352, 2010. Increasing the journalistic impact of the governor's messages by including media that focus primarily on news dissemination, have some longevity in the business, and possess the ability to craft newsworthy stories and increasing journalistic integrity by favoring media that avoid real or perceived conflicts of interest or entanglement with special interest groups, or those that engage in advocacy or lobbying. Id. At 610. This court agrees. Importantly, reliance on a professional credentialing body also tends to reduce the risk, but apparently fears most, that the White House will discriminate against journalists based on their relationship with the White House. See, for example, PL.Test Crossmo. And Oppen at 24, alleging the White House sought to exclude him from the press area. But stresses that the credentialing scheme is uniquely susceptible to abuse because the press gallery committees are comprised of a group of journalists who work for news outlets that have a strong institutional foothold in the Washington, D.C. media ecosystem. PL.S. Crossmo. And Oppen at 12 to 13. But on his own logic, the gallery review process seems less susceptible to abuse than the apparent alternative of review by the allegedly biased White House. Under the hard pass policy, the White House has constrained its discretion to exclude speakers it disagrees with, except through the conduct policy, which is not challenged here. Instead of employing discretion in determining which journalists are eligible to hold a hard pass, the White House press office and the Secret Service employ 6 clear and definite standards that are not amenable to discretionary judgments, one of which is whether the applicant holds a Supreme Court or congressional press credential. Leaves. Mo. At 15. This procedure reduces the risk highlighted in the unbridled discretion cases that a government official, here, the White House, might allocate licenses, hard passes, based on the views of certain speakers, reporters. Szymanski, 138 South Court of 1891, expressing concern that, without objective, workable standards, an election judge's own politics may shape his views on what counts as political. City of Lakewood, 486 U.S. at 763-64, explaining that in the absence of standards governing the exercise of discretion, a government official may decide who may speak and who may not based upon the content of the speech or the viewpoint of the speaker. This point that a hard pass seeker may not want to cover Congress or the Supreme Court is well taken, but it does not defeat the other reasonable features of the credentialing gallery. Requirement. A regulation can be reasonable without being the most reasonable or the only reasonable limitation. Cornelius, 473 U.S. at 808. If the White House had its own press gallery, but required journalists to seek a credential from the gallery of another branch of government, the reasonableness of the requirement might be more significantly undermined, but those are not the facts presented here. 8. Finally, Ateba argues that the congressional press credentialing requirement violates the unbridled discretion doctrine because the press galleries are not required to make decisions in any specific period of time. PL.S. Crossmo. And Oppen at 12. His concern, as articulated in some prior unbridled discretion cases, is that the decision maker will indefinitely suppress permissible speech without giving a reason. FW/PBS Incorporated v. City of Dallas, 493 U.S. 215, 227, 1990. Opinion of O'Connor, J. The court is wary of applying the extraordinary procedural protections of content-based prior restraints to the application here of content-neutral criteria for press credentialing. As the D.C. Circuit has acknowledged, MOSD circuits have held content-neutral. The extent to which a journalist must actually cover Congress to obtain a congressional press gallery credential is not clear. The Senate Daily Press Gallery rules state that an applicant must establish that he or she requires on-site access to congressional members and staff. Senate Daily Press Gallery rules. The House Periodical Press Gallery rules, by contrast, only require that an applicant justify the need of congressional press credentials. House Periodical Press Gallery rules. And the White House's long history of requiring such credentials as a
either the White House
prerequisite to obtaining a hard pass. The court infers that such credentials can be obtained even by journalists who focus their attention on covering the White House. See Sherrill, 569 F.2D at 129 N.19, noting that the White House stated that the applicant is required to have a pass to the House and Senate
In my
galleries
opinion,
because
he's
it
a
verifies
respectable
the
journalist. He seems
professional credentials
made
of the
himself
applicant.
into a household
Licensing
name.
schemes need
I
not
know
contain
at
explicit timeframes for
Thanksgiving,
processing permit
I heard his
applications.
name come up a bunch.
U.S. of Interior, 615F.3D 508, 518, D.C. 2010, C. Griffin v. Sikiev. Veterans IFs, 288F.3D 1309, 1328, Fed. 2002, noting that the procedural safeguards requirement generally comes into play where an explicit censorship scheme, which by definition is not content neutral, is under attack. Here, the press gallery regulations are content neutral, and it does not face a prior restraint on the publication of news articles. Moreover, he still has access to the press area with his day pass during the credentialing process, such that his speech there is not entirely curtailed while he awaits a decision. Accordingly, the court does not find it appropriate to apply the strict procedural safeguards of timely decision-making. In sum, the court concludes that the hard pass policy, as it incorporates the requirements of the congressional press galleries, is facially reasonable and viewpoint neutral. 3. Viewpoint discrimination challenge to the hard pass policy. Separately claims that the White House violated the First Amendment by engaging in unconstitutional viewpoint discrimination against him. His argument is not that the hard pass policy itself discriminates on the basis of viewpoint by, for example, providing access only to reporters working for liberal-leaning news organizations. Rather, his allegation is that the White House intentionally rejiggered its hard pass criteria and canceled existing passes because of Mr. His protected speech. PL.S reply in sub of Mo. For some. J. ECF number 29. PL.S reply. At 14. The White House seeks summary judgment on this claim, while but urges the court to deny summary judgment and afford him the opportunity to obtain discovery. Because the court concludes that has failed even to state a plausible claim. Ashcroft v. Iqbal, 556 U.S. 662, 678,
That's
2009.
wild.
Discovery will be denied, and the court will dismiss the claim.
That's
9.
wild.
The government may violate the First Amendment when it regulates speech based on the specific motivating ideology or the opinion or perspective of the speaker. Reeve. Town of Gilbert, 576 U.S. 155, 168, 2015, quoting Rosenberger v. Rector and Visitors of University of Virginia. 515 USA 19, 829, 1995. The government may not deny access to a speaker solely to suppress the point of view he espouses. Lambs Chapel v. Central Moore Riches Union Free School Dist, 508 U.S. 384, 393, 1993, quoting Cornelius, 473 U.S. at 806. Viewpoint discrimination occurs when the government targets a specific premise, a perspective, a standpoint from which a variety of subjects may be discussed and considered. People for the ethical treatment of animals v. Tabak, Civ. A number 21 to 2380, BAH, 2023 WL 2,809,867,
And there's a few other things I wanna
DDC
talk
March
about
31st, 2023, quoting Rosenberger, 515 U.S. at 831. The thrust of the complaint is that the White House generally ignored was written and oral questions and refused him access to President Biden. Campbell, Pilcrow 42 to 44. Frustrated, he took to assert himself in the briefing room, speaking over other reporters and the White House press secretary in an attempt to make his concerns known. Pilcrow 5. As examples, he highlights one notable incident in which he interrupted the press secretary's introduction of the Ted Lasso cast by questioning why he has not received any responses to his written inquiries or been given the opportunity to ask a question during the press briefing. Pilcrow 49, and a number of other occasions since December 2021 in which he asserted himself during briefings. 9. After the court denied his motion for a preliminary injunction, the court ordered the parties to file expedited summary judgment briefing. The White House has, thus, not filed a motion to dismiss, apart from a footnote in its opposition to his motion for a preliminary injunction, requesting that the court alternatively dismiss the complaint. CDFs. Open to PL.SMO. For prelim. Inch. ECF number 17, at 6N.2. However, at oral argument on the summary judgment motions, the parties agreed that the issue of the viewpoint discrimination claims plausibility had been sufficiently briefed for decision. Seeking answers to his questions, Pilcrow 52. He claims that the significant media coverage focusing on his conduct in the briefing room prompted the Biden White House to act by adopting the hard pass policy that resulted in deactivation of his pass. Pilcrow 54, 62.10. Assuming the truth of his allegations, he has alleged discrimination based on his conduct in the briefing room, not any view he holds or shares in his reporting. His claim is that the White House sought to exclude or limit his access to the press area to prevent his disruptive behavior, but his conduct is not itself a viewpoint. Ciabra v. Hilliard, 639 F.3D 545, 553, D.C. 2011. Regulations that prohibit disruptive speech regardless of its message plainly do not discriminate on the basis of viewpoint. Eichenlaub v. Township of Indiana, 385 F.3D 274, 281, 3D. 2004. Concluding that a motive to prevent badgering, constant interruptions, and disregard for the rules of decorum is sustainable and content neutral. See also Cornelius, 473 U.S. at 811. The First Amendment does not forbid a viewpoint neutral exclusion of speakers who would disrupt a non-public forum and hinder its effectiveness for its intended purpose. In his summary judgment reply brief, his fourth substantive brief in this case, belatedly pivots and suggests that the White House disliked his focus on U.S. relations with African nations, which Mr. seeks to cover at the White House. PL.S reply at 14, citing Campbell. Pilcrow 3 to 4, 44. IT is a well-settled prudential doctrine that courts generally will not entertain new arguments first raised in a reply brief. Benton v. Laborers Joint Training Fund. Tin Wild's viewpoint discrimination claim reads more like a First Amendment retaliation claim. He has not briefed it as such. In the D.C. Circuit, TO state a claim for First Amendment retaliation. A plaintiff must allege that 1. He or she engaged in conduct protected under the First Amendment. 2. The defendant took some retaliatory action sufficient to deter a person of ordinary firmness in plaintiff's position from speaking again. And 3. A causal link between the exercise of a constitutional right and the adverse action taken against him or her. Black Lives Matter DCV. Trump. 544 F sub. 3D15. 46. DDC 2021. Quoting RFV. Lynch. 833 F.3D 242. 258. DC 2016. The court does not pass judgment on whether revocation of a hard pass is sufficiently adverse action as to deter a person of ordinary firmness in plaintiff's position from speaking again, and, thus, whether this claim could survive if briefed within the retaliation framework. See Bingham. Center. 448 F sub. 3D at 326 to 27. 121 F sub. 3D 41, 51, DDC 2015. Internal quotation marks omitted. Doing so is not only unfair to the defendant, but also risks an improvident or ill-advised opinion on the legal issues tendered. Id. Quoting McBride v. Merrill Dowen Farm, 800 F.2D 1208, 1211, DC 1986. But even if the court were to consider the argument, the complaint alleges no facts supporting an inference that the White House adopted the hard pass policy to silence discussion of U.S.-African relations or because of misfocus on this topic. 11 but does not claim, for example, that the White House has generally sought to shut down discussion of that topic, or that others who cover that topic similarly lost their press passes. That, the White House, put in place a much broader ban. Suggested was not discriminating against the views of AFD, 901 F.3D at 367. While the facts alleged in the complaint support an inference that the White House press office disfavored even before he began disrupting press conferences, those facts do not support the further inference that his viewpoint, or even the content of his speech, has anything to do with this disfavor. He alleges that over 5 years as a correspondent, he has rarely received any response to his questions and has been permitted to attend a press conference with President Biden just once. Compel. Pilcrow 42 to 43, Ced. Pilcrow 3, alleging he has had almost no opportunity to meaningfully communicate with the White House. Id. Pilcrow 46 to 53, suggesting that his outbursts were treated differently from his colleagues. It is true that the Supreme Court has at times suggested that speaker-based discrimination suffices to raise a speech discrimination claim. 12C Citizens United, 558 U.S. at 340 to 41, holding unconstitutional campaign finance regulations based on the corporate identity of the speaker, C11 in the complaint, but briefly asserts a claim for content-based discrimination, the general category into which viewpoint discrimination falls. Compel. Pilcrow 91. However, he has failed to elaborate on this theory in any of his briefing on the preliminary injunction or summary judgment. The court, therefore, considers the argument forfeited. Aldemini v. Adelson, 916 F.3D1, 6, DC 2019. 12 but primarily raised this argument in his preliminary injunction briefing. CPL.S reply in sub. Of Mo. For Berlim. Inch. ECF number 18, at 13. Also Certa v. Hyde, 665 F.3D 860, 870 to 71, 7th 2011, holding unconstitutional mayor's exclusion of one particular speaker from participating in a public meeting. However, before and after Citizens United, the Supreme Court has primarily followed the principle that speaker-based discrimination is prohibited when and because it accompanies content discrimination. See Sorrell, 564 U.S. at 565, Ossoff Weiner, a speaker-based approach to speech moderation and First Amendment analysis. 31 Stan. L. and Polyrev. 187, 214, 2020. Thus, as the court summarized in Reed, see her to rising the distinction as speaker-based is only the beginning, not the end, of the inquiry. 576 U.S. at 170. Although the court recognized that speech restrictions based on the identity of the speaker are all too often simply means to control content, it proceeded to suggest that speaker-based concerns arise when the legislature's speaker preference reflects a content preference. Id. Alteration in original, first quoting Citizens United, 558 U.S. at 340, then quoting Turner Broad. Cis. Incorporated v. FCC, 512 U.S. 622, 658, 1994. This complaint does not raise any plausible connection between the viewpoint of his speech, or even its content, and the White House's alleged animosity toward him. Thus, the court concludes that the complaint lacks sufficient factual matter, accepted as true, to state a claim to relief that is plausible on its face. Ashcroft, 556 U.S. at 678, quoting Bellat. Core. V. Twombly, 550 U.S. 544, 570, 2007. The factual allegations, if proved, would not allow the court to draw the reasonable inference. Banneker Ventures, LLC. Graham, 798 F.3D 1119, 1129, DC 2015, cleaned up, that the White House adopted the hard pass policy with the entity, sub silentio to suppress, views. AFD, 901 F.3D at 365. The viewpoint discrimination claim thus fails. 4. APA challenge to cancellation of his hard pass. His final claim is that the Secret Service violated the APA by canceling his hard pass. PL.S Crossmo. And Opinad 19. He asserts that the cancellation was arbitrary and capricious because the Secret Service never gave him a reason for canceling the hard passes ex ante, and the ex post explanation, offered in litigation, that too many passes were in circulation, including many that were no longer actively used, makes no sense applied to Mr. Tba, who did actively use his hard pass. Id. The White House and Secret Service have not in litigation offered any rationale, beyond the hard pass policy, for canceling his hard pass, but rather argue that the Secret Service's cancellation of his hard pass is immune from APA review because it was done at the direction of the White House press office. Leaves. Mo. At 21 to 25.1,
We were just following
actions are not subject to
orders.
review under the APA. Franklin v. Massachusetts, 505 U.S.
That's
788, 800 201, 1992. This preclusion of review also extends to certain executive offices carrying out the president's directives. See, for example, Susi v. David, 448 F.2D 1067, 1073 to 75, DC 1971, CF. Wang v. Exec. Of the President, Civ. A number 07200891, Junior, 2008 WL 180189, at 1, DDC January 18, 2008, holding that the White House Press Office is not an agency within the meaning of FOIA because it lacks regulatory authority or government function independent from the office of the President. It does not challenge the immunity of the White House Press Office from APA review. CPL.S reply at 11. Accordingly, he appears to concede that he cannot challenge the hard pass policy, a policy devised by the White House, under the APA. CED. He focuses instead on the Secret Service's cancellation of his hard pass. CPL.S reply at 11. Defendants do not dispute that actions of the Secret Service, a component of the Department of Homeland Security, may be reviewable under the APA. CDFs. Mo. At 22. See also Arise Dr. V.
Almost done here.
576 F.3D 522, 524, DC 2009. Affirming dismissal of claim without questioning the general applicability of the APA to the actions of the Secret Service. Citizens for 13. The White House also argues that the Secret Service's purely mechanical action of issuing a credential is not final agency action subject to review under the APA. Leaves. Mo. At 24 to 25. The court will assume without deciding that cancellation of this credential was final agency action. Risk. And Ethics in Washington v. U.S. of Homeland Sec. 527 F sub. 2D 101, 102, 111, 112, DDC 2007. Similar. However, the White House and Secret Service argue that APA immunity extends to agency actions when taken to carry out discretionary authority vested in the President. Detroit International Bridge Company v. Government of Canada. 189 F sub. 3D 85, 104, DDC 2016. Defendants cite a line of district court cases holding unreviewable certain agency actions taken within the authority of the President. CDFs. Mo. At 23. In Detroit International Bridge, for example, the court concluded that when the President delegated his discretionary bridge permitting authority to the State Department, the decision remained unreviewable as if it were made by the President. Id. At 100-202. But claims that these cases are factually distinguishable, as they involve special intrusions into presidential power inapplicable here. CPL.S reply at 11-12. He asserts the defendant's position would prove
APA,
too much
good
sense.
question,
Two people of the executive power
Matt.
rests with the
I
President.
just kind of
Id.
pretended like
At
I
11,
knew that
and he
one.
directs the court instead to various cases in which courts have
review.
reviewed agency decisions that implement a presidential directive. CPL.S cross Mo. And Oppen at 19-20, 20 and .8. See also
Here,
Hawaii
let me
v.
find
Trump. 878 F.3D 662, 682-81, 9th, 2017, per curiam, reviewing APA suit against the President. And the entities charged with carrying out his instructions to exclude certain foreign nationals from entering the United States.
Administrative
Relevant and remanded on other grounds.
Procedure
138
Act.
South Court 2392, 2018, OAV. Trump. 404 F sub.
Administrative Procedure Act,
109,
significant federal
147,
statute that
DDC
governs the way
2019,
administrative
undertaking
agencies
APA
of the
review
federal
and agency rule
government
implemented pursuant to a presidential
may
proclamation pertaining
propose
to
or
asylum
establish
seekers. The White
regulations
House
and
and
grant
Secret Service
federal
reply
court
adjourned that decided
oversights
cases are not
over all
because they hold only that when the President directs agencies to
agency
exercise their
actions.
authority, the agency's exercise of their own authority in the form of a regulation or other final agency action is not insulated from review merely because the President started that process. Leaves. Reply and Oppen at 11. See also Detroit International Bridge Code. 189 F sub. 3D at 104. W. The challenge is to an action delegated by Congress to an agency head but directed by the President. The President effectively has stepped into the shoes of an agency head, and the review provisions usually applicable to that agency's action should govern. Quoting Elena Kagan, Presidential Administration, 114 Harv. L. Rev. 2245, 2351, 2001. The line between agency action attributable to the President versus that of an agency is concededly blurry.
Maybe the last
Courts have
page
not
or
always
second to
articulated the
last
clear rule
page.
offered
If
by
you
the
stayed
White
with
House,
us the whole
and will
time,
have reviewed
thank
the
you very
legality of
much.
presidential orders incorporated into agency actions.
Pretty sure everybody
See,
here is
for
subscribed and
example,
has that
Hawaii,
bell button hit. If you
878
don't, if you're
F.3D
watching this
682
in the
81.
future,
But where other
please
courts should draw the line.
subscribe
Purely
to the bell and the
ministerial
like
actions by federal agencies
button.
effectuating the final step
Although
of discretionary presidential decision
I
fall
want to do
within the
more
scope of
things.
presidential
I'm trying to
immunity from the
discover
APA.
what I like
To hold
to
otherwise
do
would seriously
here.
undermine the protection afforded to
And I
the
do
President
like
from APA
reading these
review
nuts and
in certain
bolts
cases.
documents.
Raise concerns about separation of powers.
I don't
See
like
Detroit
getting,
International Bridge Code, 189
you know,
F sub. 3D at
journalists
103.
telling me
Further,
what I
finding
should
such
think.
actions
Even
reviewable would
the
suggest
more
an
reputable
subordination that all
YouTube
presidential
channels
actions
have
must
their
be carried out by
bends
the
to
President
them,
him or herself in
where
order to
you don't
receive the deference
know
Congress has chosen to give to
if
presidential
their
action.
biases
Tory CNTY.
are there or not. I certainly have my
Bush,
own biases, but at least we're all
185
reading these
Sub.
things
2D18,
together.
28 to 29.
You can come to your
DDC
own
2001.
conclusions.
Here, defendants assert, and but does not contest, the invitation of members of the press into the White House by the press office and the authority to set the non-security standards for White House press passes is discretionary authority committed to the President carried out by the press office. Leaves. Mo. At 23. Leaves. Reply and Oppen at 11. CPL.S reply at 11 to 12. The undisputed facts further demonstrate that while the Secret Service has discretionary authority to determine when a reporter is a security risk, it has no discretionary authority or role in determining whether a journalist meets the other press-based criteria. PL.S risk. To Leaves. Facts Bill Co. 1. White House press access is determined by the White House Press Office, subject to a U.S. Secret Service security review. Citations omitted. The Secret Service has no role in generating the list of press members that the White House Press Office authorizes for a hard pass. The Secret Service's role in the process of authorizing entry into the White House complex is limited to conducting the necessary security checks and the issuance, renewal of the physical hard pass to the individual press member. 3D Fleischer-Dickel. Pilcrow 13. Thus, when the hard pass policy went into effect on August 1, 2023, the White House Press Office instructed the Secret Service to deactivate the hard passes that did not meet the White House Press Office's requirements for renewal, including Mr. Tp's. Id. Pilcrow 5. The Secret Service simply rubber-stamped the White House's decision. that the Secret Service has an independent statutory and regulatory role in determining White House access. PL.test reply at 11 does not make the
This is the
deactivation of
last
frequent pass reviewable.
stretch here.
Unlike in Cheryl, the Secret Service did not deactivate BIS pass for security reasons. If the president sought a change in security protocols,
Thank you,
and the
Josh.
Secret Service enacted a new rule to enforce them,
Thank
such
you.
action might be reviewable. But that is not what we have. Here, the deactivation reflected the White House's change in policy as to which journalists were entitled to expedited access. The Secret Service's mere involvement at the final step does not warrant review. The futility of APA review in these circumstances further supports the court's conclusion that the Secret Service's decision is unreviewable. This complaint is that the Secret Service failed to provide any reason to justify terminating Mr. Atebas' hard pass, let alone a good reason or reasoned explanation. Compel. Pilgro 101. Yet, his own complaint acknowledges that the Secret Service appears to be relying on a policy issued by the White House Press Office. The Secret Service declaration confirms his suspicion. If the court held in favor of Ateba, the appropriate remedy would be a remand to the Secret Service to provide a reasoned explanation. But remand here would either be entirely unrevelatory, the White House told us to, or it would provide a backdoor to review the White House's decision-making. Cf. Judicial Watch Incorporated v. U.S. Secret Serv. 726 F.3D 208, 225, DC 2013, refusing to permit plaintiff to access White House visitor log records from the Secret Service, when such records would disclose otherwise exempt information about the appointment calendars of members of the White House office. Accordingly, the Secret Service is entitled to summary judgment on the APA claim. V. Conclusion: for the reasons explained above, the court will grant summary judgment to the White House and the Secret Service on counts 1 and 3 and dismiss count 2 without prejudice. A separate order to this effect accompanies this memorandum opinion. /S.
Okay, well, at least now we're all caught up, right? We know what his complaint alleged, and we know why the court ruled it did. And it seemed like they were reaching for excuses that barely even applied them. And in some cases, they came so close to arguing for Simon, but there's a bunch of bureaucratic mess here that we can, fall back on as an excuse. And at the end of the day, I really hope Simon wins his appeal. I do want to talk about some other stuff here, but the judge says that there are too many layers of delegation, so Ateba isn't entitled to any explanation. Right? It seems like, well, he has his day pass, and that's sort of a remedy, even though it's really it's really a burden. But he still has the ability to get in there, and so, the arguments I thought he would make, I didn't see time, place, manner restrictions. Time, place, Okay, well, content neutral, time, place, and manner restrictions in public forums must be intermediate scrutiny. They must be narrowly tailored to serve a significant government interest, right? The government has more latitude in regulating access to non-public and limited public forums, right? It seems like they targeted him, they made some rules to punish him retroactively for asking tough questions. And as, I think it must have been Josh pointed out, or if he was, say, a group who's, considered, victims day in and day out, the trans community or one of the letters in the alphabet soup gang, would he be called on? Probably. But yeah, you gotta wonder, if those people started asking tough questions too, would they also get their credentials pulled? And I think that's probably, with so much manipulation, everybody seems to be gravitating towards sources they can trust. Josh is right. Absolutely. Yeah. I mean, the reason that Simon became someone that I knew who his name was is because he asked tough questions in an environment that's, it's, you got to have a backbone to do it. And he does have the backbone to do it. And there's so many other people who I used to respect, journalists and, let's say, late night talk hosts who I used to enjoy. I don't enjoy them anymore. It's really hard to watch, and it's sad in a lot of ways. And we can, talk about this more, but I was just thinking towards the end here, about some different cases that are coming up that are, in pop culture right now. And I was wondering if in Australia you guys have seen the curious case of Natalia Grace. She was a dwarf from the Ukraine who was adopted, and it just hit like HBO Max this weekend, I think, and so I binge watched it yesterday. And interesting, because for the whole previous year, the press made you think that this little girl was an adult who was trying to kill her family. Spoiler alert: the journalists got it wrong. And I don't want to ruin too much of it for you, but the at one point, and this is a very important point, it's not, the whole thing doesn't hinge on it, but a judge, Yeah, this is a fairy tale. I know. It's hard to watch, honestly. They had her re-aged from like 8 to 22 years old because they thought she was trying to pull a fast one. It turns out it was one of those terror mothers, like, Olympians. They tend to have mothers who are smothers. It's similar to that. She had 3 sons. The first son she made $500,000 off of. She wrote a book about him. He had autism, but he still ended up being a genius, and it was how she achieved that with him. And then she tried to do the virtue signaling, I'm going to adopt, and it didn't work out. When it didn't work out, she had the kid re-age so they can just boot her, kick her to the curb. And there was a subsequent court case involving their neglect. And it blows your mind because the judge doesn't want to relitigate the kid's age, which it's very important. If you listen to the jury, they would have come up with different, at least in one case, they would have come up with a different verdict had they known that she was re-aged, but it wasn't even allowed in. She was re-aged by 15 years. So what they end up doing at some point, they move her out of their house, their family home, and into apartments, into an apartment not made for a little person, by herself. She's 8, 9 years old at the time, and it breaks your heart. I know in 2023 when I first read the story, I thought she was someone who was causing trouble. You hear about that from time to time as adoptions going wrong and the kids don't fit in, and sometimes there's violence, and that was part of the story here, but it seems like it was a story. Yeah, Adopting a Dwarf is an odd flex. It is. Where do I watch this? I think it was HBO Max. The Curious Case of Natalia Grace. And it's heartbreaking, and I don't understand. I know maybe the judge thought his hands were tied, and it wasn't an appellate. No one was appealing it, and it wasn't part of this new case, and so they just didn't want it allowed in. I want to go through the filings, is what I want to do. There's 2 seasons. I think they all dropped at the same time. I think. Or season 1 may have been last year at some point. But I watched the whole thing this weekend. And it's really upsetting. Because I don't know if you've ever been in a position where something happens and you think, wow, that little girl's a real piece of work. And then you find out that the parents are the monsters. I felt bad. I feel really bad. I mean, I have an 8-year-old daughter, and I can't imagine dropping her off in an apartment and saying, good luck, sayonara. That's just nuts. Did the Ukrainian dwarf get a hard press pass, though? Was she a victim or what? I mean, it seems like every step of the way she was the victim, and she would have gotten the hard press pass, right? Yeah, what the parents made it seem like they were the victims, and then the husband, man. I've never seen a man cry so much. He, pretended to be, it seemed like, the victim of his wife. The dude needs a testosterone shot. I'm sure of this. This much I'm sure of. This much I'm sure you'll be sure of by the time you're done seeing it, because he cried more than the little girl. But, yeah, at the end, it doesn't seem to be plausible that she's an adult. She's not an adult. Every doctor seems to come to the same conclusion. She had her baby teeth when she was 6 through 8. Like most kids, they get their adult teeth in that time period too. And she had the same thing. That the parents were ignoring all the doctors. They got some experts that would go along with what they say. It really is. It needs to be studied. It'll be studied in law schools, I'm sure, at some point. But Curious Case of Natalia Grace, and that is on. Where could we find it? I'm pretty sure it's Max, HBO Max, or something like that. Where to watch? That's the... Okay. Curious Case of Natalia Grace. Netflix. Or Discovery Plus. Or Max is where you can watch it. And that's where I'm going to leave it off today, guys. I really appreciate you joining me. It was a good stream. Like I said, I didn't know much about the Simon Ateba of it all, and now we're really all caught up for the most part. Yeah, so I really appreciate it. Thank you so much. We're going to see The Beekeeper tonight, my wife and I, date night. Hope to see you all soon, Monday, maybe tomorrow. Maybe we'll cover the Natalia Grace of it all. Cheers. I'll see you later, and be well. Bye, everybody.